The consumption of food and beverages in Senate rooms is prohibited. If you wish to address this committee, please be prepared to approach the lectern when public comment is requested. Identify yourself for the record and observe the stated time limits.
All right, folks, we need to get going. Welcome to the Courts of Justice meeting. For members, there are bagels in the back. Sorry, everybody, I couldn't get bagels for everyone. But thank you for coming out this morning. Michael, MJ, could you call the roll, please?
Mr. Chair, you have a quorum.
Thank you, MJ. So just explain to everybody how this meeting is going to work. We've got one little bill to send out. Then I'm going to call the finance chair on her bill. And then we're going to do the finance bills first because those have to get done today. Then after we do the finance bills, we will move to the people who've signed up to speak and go through that order and then do committee member bills last. So that's how I intend to run the docket for people so they can plan. So the first bill I want to bring up is Senate Bill 293 by Senator Rome. That bill needs to be carried over to 2025. Senator Deeds moves and Senator Boysko seconds that we do that. The clerk will open the roll. All right.
Ayes 11, no 0.
Okay, thanks, MJ. The bill's carried over. Next up, we have the finance chair, Senate Bill 588, and she appears the waters part. Good morning, Senator Lucas.
Good morning, Mr. Chairman, members of the committee. Senate Bill 588, of course, is the housing bill that was introduced in earlier years. And Mr. Chairman, is this mic on? It is on now. Okay, what the Senate Bill 588 does, it attempts to address another of these unseen stumbling blocks to access to rental housing for the citizens of the Commonwealth of Virginia.
Hey, Senator, can I hold you on for a second? I think you got some amendments you're going to do, right?
Yes, I do, Mr. Chairman. There are.
And are they different than the ones in the packet? Sabrina?
Yes, Mr. Chair. One of the amendments have been distributed to everybody, but there are 2 additional line amendments from what you have in your packets up on the dais. So the first line amendment is on line 43 after means. You're going to strike the remainder of line 143 and all of lines 144 and 145 through rent on line 146 and insert the same as that term is defined in 15 U.S.C. Section 1681A. On line 337, after from, so we're in the enactment clause now, insert apartment and office building association of Metropolitan Washington. And then the third line amendment, also in the enactment clause on line 338, after Virginia, the first instance of Virginia, insert Virginia Apartment Management Association, comma, Virginia Association of Realtors.
Okay, so Sabrina, basically what the amendment does, it adds 2 people to the working group and it conforms the Virginia definition of adverse action to the definition of adverse action under the Fair Credit Reporting Act, which is federal law, right?
That's correct, Mr. Chair.
Okay, Senator Dees moves, Senator Boysko seconds the line amendments. All those in favor say aye. Aye. Anybody opposed? Nobody's opposed. Okay, Senator, so go on. Yep, go on.
Thank you, Mr. Chairman. Further, the intent of this bill mirrors efforts taken in 2016 by HUD at the federal level when new guidance was issued as to how to apply the Fair Housing Act standards to the use of criminal records screening in housing-related actions. HUD further strengthened the effort in 2022, providing more guidance, further clarifying its 2016 directive on this matter, to include recommendations that private housing providers avoid using criminal history to screen tenants for housing. That's essentially what the bill does, Mr. Chairman.
Thank you, Senator Lucas. Anybody have any questions for Senator Lucas? No questions. Okay. Is there anybody opposed to the bill? Doesn't look like anybody's opposed. Nobody. Okay. I'm sorry. This bill has to be re-referred to the. Senator Reeves, you want to oppose the bill? Doesn't look like it. Okay. So this bill needs to be re-referred to the General Laws Committee. So Senator Deeds moves to report the bill re-referred to the General Laws Committee. Senator Boysko seconds that. Clerk will open the roll.
Ayes 11, noes 2.
Great. Bill reports re-refers. Thank you, Senator.
Thank you, Mr. Chairman, members of the committee. You all have a good evening.
You too. Good morning. Good morning. Good morning. Man. Okay, so next up, I'd like to call one of the more complicated ones we have, Senator Deeds. You have 427, right?
Sure.
Do you have a substitute on that?
There is a substitute on 427. It's a second look bill. The substitute should be at everybody's desk. It's been distributed.
Senator Deeds moves,
move
Senator
it.
Boyce goes seconds. The substitute, all those in favor say aye. Aye.
420
Anybody opposed? Nobody's opposed.
427 is a second look bill. We passed it out of the Senate twice with bipartisan support. The substitute is a little bit different from what you've seen before. It changes the format to a tiered system based on the type of offense, allowing individuals to petition the court for a modification of their sentence after 25, 20, or 15 years have been served. The introduced version of the one that passed the Senate last year excluded some crimes but allowed the individual to petition the court after 15 years. The substitute also incorporates changes from the Office of the Executive Secretary that had concerns about the influx of petitions, just in terms of how you handle them. So this bill is about compassion and fiscal responsibility. It recognizes that individuals can change and be rehabilitated. The bill provides an incentive for those who are incarcerated to engage in therapeutic and educational programming and to seek redemption. Since we have considered the underlying policy before, I just wanted to remind you of a few things. An individual is limited to filing a petition twice and must wait 3 years if the first petition is dismissed. The petition must be filed in the circuit court that entered the original judgment and heard by the same judge if possible. The law also permits the judge to dismiss a petition in chambers if a determination is made that it lacks merits. In those instances, no hearing is held and notifications are not made to the Commonwealth or to the victim. Otherwise, the Commonwealth attorneys engaged in the victim is to be notified and involved in the process. The bill delineates factors for the court to consider, including a victim impact statement along with characteristics of the petitioner, both at the time of the offense and now compliance of the petitioner with the Department of Corrections. And whatever case plan they have, whatever plan for release they have. The bill also stipulates that plea bargains may not include a waiver of the right to petition for a sentence modification. The reality is we are incarcerating individuals well beyond when they are likely to reoffend. In some states that have implemented second look laws, the rate of recidivism for those individuals is just 1.6%. Virginia's overall recidivism rate currently is about 20%. JLARC determined that SB 427 would disproportionately impact black inmates because a higher proportion of eligible inmates are black relative to the proportion of black persons in Virginia. That's the bill. The process is not a lot different from what we've seen before. Just the tiered approach is different.
Thank you, Senator. I'd also like the committee to note that I asked for JLARC to prepare a racial and ethnic impact statement on this bill, which you can find online under the impact statement portion of the legislation. We can only do 2 of those per year. This is one of the ones we did it on.
Is that to the substitute or the original?
To the original bill.
The original bill.
Yeah.
So not what we're talking about.
Mr. Chairman. Hold on, Senator Deeds.
The original bill the original bill allowed people to petition after 15 years. This allows people to petition after 25 years for some offenses, 20 years on other offenses, 15 after other offenses. So I would argue that the racial impact is the same or greater under this bill than. But
Okay.
Again, the impact was to the original bill.
Okay. Senator Obenstein was ahead of you in the queue, but you can go ahead if you want.
Mr. Chairman,
Senator McDougal.
This was just to be clear, though, that the impact that's posted online is not to the bill that we're discussing now. It's to a prior version.
I think that's right. If you look at the first sentence, it says incarcerated for 15 or more years and doesn't talk about the tiered system that Senator Deeds mentioned. Okay? So Senator Obenstein.
Mr. Chairman, I've got a practical question. We have done a lot over the past 5 years that has altered the workload of our circuit courts. While I see the racial and ethnic impact statement, I do not see anything related to the additional circuit court judges that we're going to need or the impact on the dockets, which are increasingly backed up. I know that right now I can't get courts to schedule cases until 2025. Do you have any, does the patron have any information about the number of additional circuit court judges that we're going to need across the state in order to manage this caseload?
Senator Deeds.
Mr. Chair, I would say to Senator Obenshain that I think we have plenty of circuit court judges, and there's nothing about these petitions that puts them at the front of the line. If it takes a while for the case to be heard in the circuit court, that so be it. The gentleman is aware that the senator is aware that we've shut down, or the governor's proposed shutting down 4 prisons. That's because we have fewer inmates now than we did just a few years ago. I would suggest that this is probably not going to be utilized that much, but the reality is that for some of these guys that are in prison for a long period of time, they've got to have some incentive to comply with the rules and try to improve their lives. That's why this legislation received support from some correctional officers groups.
I think Senator Peterson's bill last year had a couple of fiscal impact statements. It didn't talk about new judges. It talks about probation officers and some other impacts. Senator Obenshain, you have another question?
Mr. Chairman, I would say that the line just keeps getting longer in our circuit courts, and I do believe that this is going to have a significant impact on the ability to get prompt civil and criminal justice in Virginia. And I think we're just shooting in the dark and have no idea what kind of an impact this is going to have. So I thank this patron.
Senator McDougall, did you have more questions?
I did, Mr. Chairman. Mr. Chairman, and maybe this is for Senator Deeds or staff, but if this is the version I think it is, and so I'm asking if these numbers are correct, this would include the individuals in the 25-year or more criteria that would be reviewed. 185 were convicted of capital murder and 701 of first-degree murder. Is that accurate?
I don't have those numbers in front of me, but if look at the 25, we have not excluded offenses this year. So people that have been convicted of capital murder or first-degree murder would be eligible after 25 years.
So,
Senator McDougall.
Mr. Chairman, maybe if somebody from the Department of Corrections or the Secretary of Public Safety's office could come up and help us confirm. I want to make sure we're talking about the right numbers and the right offenses that are going to be
Is DOC in the room or Public Safety? Both of you? Mr. Humphreys.
Mr. Chairman, members of the committee, Josh Humphreys, Deputy Secretary of Public Safety. Senator McDougall, I do believe that those numbers are accurate based on what we requested DOC to pull.
Mr. Chairman.
Senator McDougall.
And I'm going to ask about the group in the 20 or more year category. Does that also include 128 individuals who have been convicted of manslaughter, 107 individuals that were convicted of abduction, and 77 individuals that were convicted of rape or sexual assault?
Senator Surville, Senator McDougall, yes, sir, I believe that's correct.
And Mr. Chairman.
Senator McDougall,
And
we're leading questions.
And in the category of 15 years or more, I think it's important that we talk about what we're actually talking about.
Right.
That in the 15-year or more category includes 554 individuals convicted of manslaughter, 513 individuals convicted of abduction, 688 individuals convicted of rape or sexual assault, and 66 individuals convicted of arson.
Senator Surville and Senator McDougall, yes, sir, I believe that's correct.
Thank you, Mr. Chairman.
Okay.
I want to speak to the bill.
Well, you speak it, after the witnesses. Yeah, okay. Can I hear the questions for Senator Deeds before we go to the testimony? No, okay. We have, again, 26 now, I guess, 24 bills left in our docket. We have to complete by 11:30 today, so I'm going to limit this to 5 and 5. MJ, you set the timer, so those in support, come on up, and can you please check, see if there's anybody online?
If there's anyone online that would like to speak in favor of the bill, please raise your hand.
And if you're in the room to speak to the bill, would you please mind moving
Clock's running.
as
Come
close
on
as
up.
you can to the microphone?
The clock is running. You've lost 15 seconds getting up here.
Mr. Chairman, members of the committee, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We do support this substitute and appreciate the work and care that's been put into its crafting. As the state's anti-violence coalition, with over 40 years' experience working with sexual and domestic violence victims, and on behalf of community-based agencies who do the same, we know that victims are not a monolith. We know that large majority never choose to engage with the criminal legal system, citing safety concerns and a loss of control when they do. We also know that far too many victims are criminalized and handed down lengthy sentences for fighting back, for protecting their children, and for crimes committed in the context of surviving abuse. We believe that this substitute carefully balances victims' rights with the humanity of those who commit violence. It's our hope that Virginia can make these reforms while also ensuring that victim services in every community are available and fully funded. Thank you.
Thank you. All right, 3:50. We also have 8 people online, so try to be cognizant of other people's time behind you. Go ahead.
Mr. Chairman, members of the committee, my name is Donald Baylor. I'm with the National Coalition of Public Safety Officers. We support this bill. This bill, to us, as frontline, those who work front lines of these prisons, it makes sense. I think Senator Deed hit the key word, incentive, and that's what we hope that this bill, and we believe that this bill would do. It would incentivize behavior and help these folks program and do the things that we ask of them to do. And after all, we're the Department of Corrections, and we need to provide some means for people to reform. Thank you.
Thank you. Next.
Good morning, Chair and Committee.
Williams, yep.
My name is Sheba Williams with No Left Turns. My family is now at over 20 losses in the past few years. I hurt just like anyone else. I'm angry at times. I cry. I have accepted loss after loss. I trust my God to heal me when there is no understanding. I still choose love. Forgiveness is for my own healing. I believe wholeheartedly in accountability for those who have caused harm to my family, but we all know that the systems that are in place to serve justice are unbalanced, inconsistent, and need reform. Giving individuals who have caused harm to my family a second look doesn't leave me out of the conversation as a survivor. I believe in this bill. I believe that we need to invest the $30 million that was cut in funding to victim services versus spending $1.8 billion a year in extreme sentencing and mass incarceration when it is no longer beneficial to public safety. Redemption is for everyone. Thank you for your time.
Hey, Ms. Williams.
My name is Chanel Young.
Hold on one second. We're going to add another 5 minutes to the thing, so it'll be 10 and 10, I guess. So if you make it 7 minutes.
Good morning. I believe it's important for all involved in the process, especially the victims, their families, and loved ones, to know that any legislation offering those incarcerated a second chance comes with a high level of responsibility and accountability. The men and women who will be returning to our communities as a result of this legislation are expected and prepared to continue to pay their debt to society. Their responsibility will be in using their lived experiences to combat the same violence and criminal behavior they once perpetrated on others. Their accountability will be to openly and publicly carry the shame of their crimes as they work to advocate the cause of public safety. This stigma will never leave them, no matter the spaces they move through, whether it be public or private. So instead of languishing in prison and sitting on the sidelines while crime and violence festers in our own communities, we are requiring them to invest their time, energy, and effort into these areas, as well as fulfill their obligations as a citizen. It is in this way that they not only continue to pay their debt, but additionally, they can help save lives. I stand here today and I support the second look bill. Thank you.
Thank you. Next.
Good morning. My name is Weldon Prince Bunn, and I'm just simply here to tell you that I support the bill too. I'm a returning citizen. I've been on for 6 years, and I think that it's a great opportunity to give individuals who are working to get their freedom back an opportunity. So I support the bill. Thank you.
Thank you. Next.
Good morning, Honorable Committee. My name is Troy Ketchmore. I'm a returning citizen. I did 26 years, 8 months. Wrongfully convicted in the state of Virginia. I'm the beneficiary of Fishback, a second chance, that the victim's family contacted parole board and the Commonwealth attorney contacted parole board and asked them to release me. So second chances can work out. During that time, I have an organization, Catch More Kids Incorporated. I've been home 2 years and some change. I'm about to pay taxes for the second year. So in prison, they say you want to come home and be a tax-paying, productive citizen. I'm achieving that. I've been at Red Onion State Prison, and 2 weeks ago, I was in the White House with a meeting for their head of gun violence intervention program, that they want me to go across the nation teaching our model to other cities. So I am living proof that if you qualify yourself, then you can come home and be productive. And that's all we're asking, is to get this bill on the record so that those that qualify themselves can be released. If you don't qualify yourself, we won't even be worrying about this. So again, thank you for having us. I hope you consider the bill.
Thank you. Next.
How are you doing? Senator Surville, members of the board and the committee. My name is Sincere Ola. Been out 2 years now. I'm a pardon recipient, 2022. Some of you remember me. A lot of you, were on my side when it came to advocating for my release while I was inside. Redemption is for everybody. The only way I could have gotten out, according to the older laws, was through executive order. So I had no incentive while inside to do the things that I was able to do. Since I've been home, I'm now currently the state organizer for a national nonprofit called Reform Alliance, who works with other organizations statewide and nationally to exact change in our criminal legal system all over the country and in other countries as well. So I'd like to say that redemption is for everyone. We have to earn this opportunity to be heard. This isn't something that someone's going to give us. This isn't something that we're just automatically acquired. This is something we actually earn. I support the bill.
Thank you, Sincere. Next.
Good morning.
250 left.
First of all, I'd like to thank the committee for allowing us to speak. My name is Paul Taylor, but before I begin, I'd like to say the name Julius Jeggedy, because so many times we talk about the victim, but we don't put a name to him. I'm also a returning citizen to my victim. His name was Julius Jeggedy. While on the inside, I co-facilitated all of the state-mandated programs in the Department of Corrections Reentry Program for over 6 years. One of the favorite courses was Victims Impact. I like to repeat that. One of the favorite courses was Victims Impact, where we learned from A to Z all of the crimes that was just described. And we have empathy, serious empathy for the victims of our crimes. And we just need one opportunity to come home to describe our relevance. I am a second chance. Someone took the liberty and gave me a second chance. And here I am standing before you today. A man that was given an opportunity to serve on the governor's board for juvenile justice, as well as the governor's board for the Department of Criminal Justice Service. And I'll even go further. You're looking at a man that once shared a cell, but was a community-based organizer for the Department of Criminal Justice Service Grant Department. And I have another partner with me by the name of Weldon Bunn that was also there. This is the temperament of today's returning citizens. And I promise you, with one opportunity, we shall be described as relevant. We support this bill.
Great. Thank you. Next up, we got minute 20. We still have 8 people online too, so.
Good morning. My name is Santia Nance, and I'm here on behalf of my son, who's at school this morning but wanted to be with y'all. He just wanted to say he believes in second chances, and we support this bill. Thank you.
Thank you for coming.
Talia Mallory with Virginia NAACP. Thank you, Senator Deeds, for bringing up that Black people have been disproportionately incarcerated. Further, let me just remind everyone that we treat drug offenses now very differently than we did 20 and 30 years ago during the war on drugs, whereas now those offenses are being treated as part of a mental health crisis on a mental health track. Back then, it was just lock them up, lock them up, lock them up. We support the second look.
Thank you. All right, 45 seconds.
Good morning. Monica Hutchinson with Rise for Youth, and we support this bill. Thank you.
Rob Hogan-Class, Justice for Virginia. We strongly support the bill.
Thank you.
Sky Riggleman with Americans for Prosperity. We support the bill.
Thank you.
Akiva Friedland, Legal Aid Justice Center. We support the bill.
Thanks.
Marianne Kramer, Virginia Justice Alliance. We support the bill.
Victor McKenzie, Sarah, Virginia, and we support the bill.
Sean Winetto speaking on behalf of the ACLU of Virginia. We do support this bill strongly, and we ask the committee to report it out. Thank you.
Penny Page, on behalf of Together We Will Henrico, we support this bill.
Thank you. Okay, can we go to the online folks? The folks online, just identify yourself, who your organization, and state the opponents.
Tajman Haft, you may unmute, and please make sure your camera's on.
Mr. Mayenhalf, the Humanization Project, we strongly support this bill.
Thank you for being brief.
Antoine Coleman, you may unmute, and please make sure your camera's on. Mr. Coleman, please unmute.
We go to the next one, please.
Fatima, you may unmute, and please make sure your camera's on.
Fatima Muwahed with Talib Muwahed, we strongly support the bill.
Dawn Parker, please unmute.
I'm a victim, and I also support this bill.
Kimberly Jenkins, please unmute.
Kimberly Jenkins Snodgrass, Interfaith Action for Human Rights. We support this bill.
Francis, please unmute. And make sure your camera's on.
Francis Ross. We support the group.
Juanita, you may unmute, and please make sure your camera's on.
Juanita Belton, co-founder of Sisters in Prison Reform, and we strongly support Second Look.
Sharonda, please unmute and make sure your camera's on.
Thank you, Chairman and members of the committee. My name is Sharonda Hubert, and I'm from Lynchburg, Virginia. This is my 2-year-old son, Simeon. Almost 11 years ago.
Sorry, man, we've already taken testimony. We're 2 minutes over in support. So I just need you to stay who you are, where you're from, and that whether you support the bill or not. That's all.
I do not support the bill. I'm from Lynchburg, Virginia. Thank you, sir.
She said she does not.
I think she said she does not. Yeah.
I
Yeah,
do
she
not.
should be.
Thank you.
Okay, yeah, you should be in the other queue then when they call for opponents.
Okay, thank you.
Mr. Chair, that concludes our online speakers.
Okay, now we're going to go to those who oppose the bill. If you oppose the bill, come on up, and we're going to reset the clock to 10 minutes.
If there's anyone online that would like to speak in opposition, please raise your hand.
Go ahead.
Hi, my name is Melinda Wallen, and I'm here for the safety of Virginia. August 12th, I lost my son, and I held him in my arms when he died because 2 men wanted to come into our neighborhood and deal with drugs and wanted to go after our neighbors to kill them. Mr. Rhodes is from the military who was discharged because he shot his sergeant. 2 years after that, he comes and he comes to our neighborhood, holds my son down to be shot by William McDowney. William McDowney had a long life of violence. He went and terrorized 5 of our communities of Virginia: Henrico, Stafford, and Fredericksburg, and I forgot the other one. I think it was King George. William McDowney kept on getting out on bond. He was out on bond. 3 weeks after he was out on bond, he shoots my son in the back, and he died. He bled out in my arms. We were threatened repeatedly on the stand. I went and stayed strong so that my son could get justice for him dying. Too many people are dying. Too many people are getting hurt. And repeatedly because we're bending the laws. We need to stop bending the laws. And we need to start getting stronger, Virginia. We need to fight against crime. Crime is growing. And we got to stop it. And I'm here to say I'm going to keep on. And I'm going to stand up that we can get stronger, Virginia. And we put our foots down on crime.
Thank you for coming. Next.
Yes, my name is Michael Gray, and I'm here to speak on being against this bill.
Mr. Gray, where are you from?
I'm from Richmond, Virginia. I will remind this committee, if they haven't heard, 5 years ago I received a phone call. I was in Memphis, Tennessee, from Detective Coates. He said, is this Mr. Gray? I said, yes, sir. He said, I need to speak to you about your son, Joshua Gray. I said, okay. I said, and let me get his mother on the phone, got Diane on the phone. Mr. Coates proceeded to ask me if you were in Richmond today, and I said, no, sir, I'm in Memphis. He said, well, I hate to do this over the phone, but your son's been shot and killed. Josh was shot and killed trying to sell an iPhone. He went on an app called Let Go. Met the guy, it's on video, shows up, goes out, hands the phone out. A 15-year-old gentleman pulls out a gun and shoots him, okay? Over the next year, I can't explain the traumatic events that occurred for our family, my wife, my children, and the court proceedings. For this bill to be put in place to allow criminals, okay, to have an ability to petition to come back out, okay, and to put victims back in the same courtroom that we were in 10 years ago, 15 years ago, 20 years ago. I'm not a proponent. You just don't understand, and I'm gonna. You should never assume, but I'm going to assume that no one up here has ever lost a child due to a senseless act, and the impact it's with us every day. That was over 5 years ago. What I will show you, and I'll be respectful of the time behind me. This is Josh. Okay, that's my son. All right, he wanted to be a model, whether he would have been. Okay, that's the last picture I remember of my model son, right there. Okay, this gentleman right here was sentenced by a pair of jurors, right? I mean, why have a justice system if we're going to circumvent these decisions and try to come back and let these people get out of jail? I have 20 seconds. Over the last 5 years, you may have seen this billboard, and you may have not seen this billboard, okay? I have these billboards up in 8 states. My goal is to go coast to coast, saving lives, trying to protect people from selling online, okay? I'm completely against this bill, and I hope you consider the same.
Thank you. Sorry for the loss of your son, sir. Thanks for testifying. Next up, we got 4 minutes and 55 seconds.
Good morning. My name is Kristen Hubbard, and I first was introduced to bills like SB 427 with IRA in Washington, D.C. And I think it's interesting that we're talking about the impact, the racial impact here, because IRA, as you all know sitting up here, bills like SB 427 were rolled out in predominantly black and brown jurisdictions, about 24 of them. Those victims are black and brown as well. So you need to ask yourself which lives are mattering to you, which black and brown lives impacts are mattering to you. I'm sitting here today with my father, retired captain in the Navy, Robert Hubbard, grew up in Watts, Los Angeles. And we are saying that 25 and under, you don't have the capacity to know the difference between right and wrong. Well, at 18, he was jumping out of planes in Vietnam and served his country proudly. We are a military family. And I have to say, it's very disheartening to hear words from Senator Deeds about compassion mixed with fiscal responsibility. So this is tied into a financial matter. I was 18 years old when I was abducted with another student. We were kidnapped at gunpoint, repeatedly raped, beaten, made to dig our own graves. And you think that that is sufficient, 15 years, 20 years, 25 years. I have a life sentence, sir. I don't get a second chance. I don't get parole. For you to even lightly suggest that the victim won't be contacted directly, that is shameful to ever say. That is absolutely despicable to allow. 30 years ago when I was 18, I had a representative for me. I had a victim's advocate. I had detectives. They're all retired. They're all retired now. So you expect the attorney that was working on someone's case to personally contact that person. That's disgusting. They should be contacted irregardless. The reason why I come here after 30 years, ladies and gentlemen, is because if I don't, you're not going to feel the impact. Someone's going to read my statement, and they will if I'm not here anymore. My family will be here to do that. But I'm here to impress upon you that this impact that it has, 554 manslaughters, 515 abductions, 688 rapes, you mean to release. People are up here talking about redemption and how they changed their lives in prison. You're supposed to do better. You're supposed to want to do better. I grew up in a household where black excellence, black excellence was expected from us. Doing better was expected of us. And we're not an isolated family. There are millions of families across this country that are black and brown that feel this way.
Could you try to wrap up? You got 3 online, you got 3 behind you. And
I just want to end that I'm curious by people saying that they're representatives of sexual violence in this state voting for this bill. Thank you.
Okay, thank you for coming.
Hi, my name is Paige O'Shaughnessy, and I am a victim. Rather than go into all the details
Ms. Shaughnessy, where are you from, please?
Excuse me?
Where are you from?
I'm from Norfolk, Virginia.
Okay, thank you.
I really would like to ask you to look at several parts of this bill that I find kind of upsetting. As far as the notification of victims, I want you to know that it is not the state or the Commonwealth Attorney's Office to stay in touch with us. It is the victim's obligation to stay in touch with what is going on with the victim. So once again, I don't know how you would expect them to get in touch with us if they've never kept track of us. The enforcement of this bill is another concern I have. You use the word petition. From a geriatric parole standpoint, they also use the word petition. However, they are automatically scheduled a hearing once they become eligible. I am sure that while you're using the word petition here, the same will happen here, because God forbid someone not be notified of their right to petition for this second look. I have other issues that I would love to address with you relating to this bill. I'd like to thank Senator Obenshain for some of the issues that he brought up, because those are my concerns well, as far as the impact that it has on the judicial system. I know in my case, my husband was murdered 23 years ago. Not only is the judge no longer practicing, he's retired, but the Commonwealth Attorney and all of the other attorneys that worked on that case have also retired. Thank you.
Thank you. We're 30 seconds over. The other side went 2 minutes over. Mr. Green, we also got 3 people online. If you want to say something really quick, we got the 3 online.
Nathan Green, Commonwealth Attorney for City of Williamsburg, James City County. The Virginia Association of Commonwealth Attorneys is opposed to the bill. I'll only address one thing that was because the question was asked. They do go to the front of the line. The bill has a shall be done within 90 days.
Thank you, Mr. Green. Okay, can we go to the online folks? Make sure you turn on your cameras.
And please unmute and make sure your camera's on.
Yes, briefly, were this a sincere effort? The JLARC study would include an impact statement for victims. They are real and they do deserve consideration, and they should be included in that study before you make any decisions. Thank you.
Dennis Brown, you can unmute and make sure your camera's on.
Good morning, Mr. Chairman, committee members. My name is Dennis Brown. I live in Blair, Virginia. And
Mr. Brown, make sure we have 30 seconds, so make sure you're quick.
And I'm the father of a son who was murdered. My son graduated from high school in 2016 with a 4.0 in 2 years of college. However, he was targeted by an individual in the community. A 17-year-old boy deliberately shot my son in his face with a .40 caliber Smith & Wesson that was stolen. Within minutes, law enforcement were able to track him because his cell number was in my son's phone. When the authorities went to the juvenile's residence, they could smell marijuana even before entering. His mother was home. Upon searching the juvenile's room, they found bags of marijuana and a sawed-off shotgun. Clearly, this individual needs to be off the streets and to pay for the crime he committed. I'm asking you today, please do not pass a law that will give a convicted murderer one less day than what a judge has given him or her. I thank you, Mr. Chairman, for my time, and I thank you for your patience.
Thank you, sir.
Sharonda, you may unmute, and please make sure your camera's on.
Can we just stay who you are, where you're from, and whether you support or oppose the bill? We're out of time.
Sharonda Hubert, Lynchburg, Virginia, and I'm opposed to this bill.
Thank you. Okay, that's it for the testimony. I guess we now need to move to the anything from the committee members. Yeah, patron. I mean, yeah, Cree, you want to wrap up, or do you want to? Huh?
We're going to want to say something too. So
Okay. Well, why don't you guys go first? Cree, get the last word.
Mr. Chairman, a couple of things that I would point out. Number one, this re-victimizes victims. And it is, the re-victimization is replete through the draft. Line 80 even refers to an offense which is alleged to have been committed. I mean, this is after somebody has been adjudicated guilty of committing the offense. Second of all, contrary to the belief of the patron, line 95 to 98 clearly state that the court shall conduct the hearing on the petition within 90 days of the filing of the petition. Everything else gets backed up. In a court that has a busy docket with trials scheduled typically a year out, it is going to wreak havoc with dockets, civil and criminal. 90 days really also doesn't give a reasonable opportunity to contact victims or for victims to prepare themselves to testify in these cases. It further does not even require the victim to be notified or for reasonable efforts to be made to contact the victim. In lines 104 to 105, it expressly states that failure of the attorney for the Commonwealth to make reasonable efforts to notify the victim shall not preclude the court from considering the petition. I find that shameful, that reasonable efforts are simply excusable. It is a hollow requirement in this bill. Victims 25 years after the fact have worked hard in most cases to put the facts of these crimes behind them, and to require them to come forth if they wish to be heard and testify again is an incredible hardship, as is evidenced by the testimony of several people here today. I just respectfully submit that we have other avenues for granting leniency and granting grace to inmates, and I would respectfully submit that this automatic review with 90 days notice and no requirement of notification of victims is simply the wrong way to go.
Senator McDougall.
Thank you, Mr. Chairman. Mr. Chairman, when we talk about this, there are real faces and real lives to individuals that will be impacted. So the numbers the Department of Corrections gave us, there are 766 individuals who were the victim of rape or sexual assault that will potentially have to go back, have a hearing, have another impact, and face the person that raped or sexually assaulted them. There are 629 victims of abduction. They'll have to be notified, provide a statement, or go back to court, and will be impacted again by the person that abducted them. Mr. Chairman, for me personally, if we were talking about drug possession, I'd vote for it. There are 5 individuals that potentially could be impacted by this bill that were convicted of drug possession. If we were talking about those 5, I'd vote for it. But we're talking about families that have lost loved ones who've been killed, murdered, families, individuals that have been raped or sexually assaulted, and families and victims that have been abducted, taken away. Mr. Chairman, members of the committee, this is terribly impactful. When we talk about a criminal justice system, there are multiple things it should do. One is to protect the community from future harm. And we should not be re-victimizing victims.
Thank you, Senator. Anybody else have any comments for Senator Boysko?
Thank you, Mr. Chair. You know, as we're talking about this, I understand that there are some horrible things that have happened to individuals, and my heart is breaking for everybody who's testified today who has a family member who's a victim of a crime. The thing that I think is important for us to realize is that people change. There is redemption, and maybe we have a difference of opinion that certain individuals are never given a second chance. That is a philosophical difference between the way I feel, which is that if someone has worked hard, if they have learned, and they are really fighting to change their behavior and to be a better person, to return back to the community is a positive thing. We've heard from some of the gentlemen who have been formerly incarcerated who are now using their lives every single day to try to help prevent further harm by working with youth who are at risk, by working with individuals to help them get on another path. That's a meaningful change. That is a meaningful, productive way of using their lives. My understanding is with this bill is that the individual who's incarcerated petitions the court. The judge has the decision whether or not it's going to go forward or not. This is not just wholesale taking everybody who is incarcerated and then putting them before a judge. They have to be able to show that they have changed, that they have done the hard work that is necessary. You know, I'm the daughter of an Episcopal priest, and, redemption is something that I think is important. And grace, as Senator Obenshane mentioned, we are working to try to help people who have absolutely turned the corner to be able to come home. And I thank the patron for his bill.
Okay. Anybody else want to make any?
Mr.
Jordan.
Chair.
Senator Jordan. Yeah.
Thank you, Mr. Chair. Speaking of the bill.
Go ahead.
This bill and hearing the testimony this morning is difficult. And while I'm a strong believer in second chances for many reasons, and I've been able to vote for many pieces of legislation prior to support things like this, today will not be one of them. If anyone in this room has a child in school, or if you attended church this past Sunday, just one of the maybe minor issues this bill would allow would be allowable to burn your child's school down, jail, or even your church, set up an explosive device, commit an act of terrorism. And I don't think 15 years would be nearly enough for loss of life that could occur in such a callous attempt to extinguish life. If you have a child that was the unfortunate subject of child pornography, the reproduction of such, the images that get disseminated across the internet that never go away, and the sting of that never go away. This is allowable in this bill. Over the years, I've worked, it's difficult work, but I've worked heavily in the space of human trafficking. If you are a man, woman, or child that's been human trafficked, and your hope when you finally break free of that bond is to be able to know that the person that committed such heinous acts against you will go away for the longest time and not be able to traffic other bodies across this country. You no longer would be able to have that peace of mind. If you're a minor, and if someone has a child in here, aggravated sexual battery, forcible sodomy, object sexual penetration, these are serious offenses. In 15 years, if someone's a minor, they could be starting college. They could be trying to settle down their first career. They could be trying to just establish their life. And that entire house of cards will come down with knowing that a person that committed such heinous acts against them could be free. I really want us to think about the charges that are in this bill and what that would mean for the victims. Because while I agree with there are so many opportunities for second chances, there are some things that are so depraved and so immoral and so wrong to society that redemption for the victims is difficult. How do we get there? How do you look someone in the face after a child has been violated repeatedly and then ask them to show up for a victim impact statement in a court in their mid-20s when they're just trying to get their life resettled? And I think that's what everyone on this committee needs to ask themselves today before you cast this vote. Thank you, Mr. Chair.
Thank you, Senator Jordan. Before I go to Senator Deeds, I just want to point out a couple things. First of all, and like Senator Boysko and I think everybody up here, some of the stories we heard today are obviously awful, and I feel horrible for all the people who've been victims of crime and the family members here whose children aren't here with us today. And it's every time I hear those stories, it makes my heart break. I just also want to point out a couple procedure things, though. First of all, I believe the notice provisions in this bill are consistent with what is required by the parole board. If not, they're pretty close. The parole board, I think, is required to revisit cases every 3 years. So all these people are getting contacted by the parole board every 3 years to provide input testimony as to whether or not somebody ought to be paroled. Our system also allows the governor to issue pardons, conditional pardons, simple pardons, but conditional pardons are the ones that often result in release. There's also habeas proceedings. Often the conviction order is not the end of a case. It's not unusual at all for there to be multiple hearings after that. We've also made some significant changes in Virginia in the last 10, 20 years since a lot of these cases were heard in terms of how we appoint counsel, what we pay them, how jury sentences are rendered. A lot of these cases came down when lawyers are being paid $300 to defend somebody. And, and we also, I think, I like to think our society believes in people's capacity to change. And people become different people over time. You heard from a few people at the beginning who talked about how prison changed their life. And I think this bill just gives the system discretion to honor that possibility. And there are some people that should stay locked up forever. And we put judges on the bench to make these decisions and make those determinations. And it seems to me that's kind of what this bill does. Senator Deeds, you want to have the last word?
Just a couple of points. What you were talking about with the notice of the victim is on line 98. The attorney for the Commonwealth shall make reasonable efforts to notify any victim. Up in the previous paragraph and in that paragraph H, it sets forth the time for petition, time for hearing. If someone has a better idea or a better approach to this, I'm all ears, and I'd be willing to accept amendments. Closure is overrated in my view. Sometimes when you lose somebody, there's never closure. There's never closure. But what we don't realize, what we're not recognizing, I don't think, is that when a crime occurs, there are a number of victims. Sometimes the person who goes away has a spouse and kids, and they're victimized too. So what we're doing with this legislation is simply trying to give people that are incarcerated for a long period of time some incentive to improve their lives and give their families some hope. This allows a petition. It's not a get-out-of-jail-free card. It's a petition to the circuit court who heard the case, and the circuit court can summarily dismiss it or can dismiss it after a hearing. It can also grant it sometimes. There are about 2,500 people in the state that will be eligible under this process. It's not going to overburden the court system. If there's a better way or a better timeline for doing this, I'm all ears. I'll make a motion to report the bill.
Second.
Report and refer to finance, I think.
Substitute motion that the bill be PBI'd.
Second. Okay, substitute motion takes precedence. No further discussion. Clerk will open the roll. Motion PBI.
Ayes 6, noes 9.
Okay, motion PBI fails. Motion to report and refer the bill to finance. Clerk will open the roll.
Ayes 9, no 6.
Thank you. The bill reports refers to finance, and thank you for everybody for providing your testimony today. We appreciate you coming to Richmond and testifying. Next up, I have Senator Durant, I think, is the next finance bill non-committee patron. And Senator Durant, you have a substitute?
Yes, Mr. Chair. Good
Okay.
morning.
Is that in the packet? Okay. So we're on Senate Bill 731. Senator Deeds, open chain moves. McDougall seconds. The substitute. All those in favor say aye. Aye. Anybody opposed? Nobody opposes. So Senator Durant, you or your counsel would like to explain to us what you did to make this clean this up.
Yeah.
Or
thank
Steve,
you.
yeah, Steve or Benjamin, somebody, yeah, go ahead. You go
Sorry.
first.
Okay. Thank you, Mr. Chair, members of the committee. I just want to appreciate everyone for working with us to get this substitute and I think the right posture. And I do have my Commonwealth's attorney back into phone a friend to kind of speak on a little bit more. But this substitute adds a second prong to this test, which in code right now, child pornography means sexually explicit visual material which utilizes as a subject as an identified minor, or obscene sexually explicit visual material which utilizes has a subject visual material sufficiently realistic in appearance as to be virtually indistinguishable from an identified minor. All right, Mr. Chair, I'm happy to have my Commonwealth's attorney who can speak in a little more.
So did this language come from that federal statute y'all mentioned?
Yes, Mr. Chair.
So, Mr. Chair, this language was a collaborative effort and very appreciative of Mr. Benjamin for helping us in the Senate work group. This language does not come from the federal statute. This language was tailored to meet Virginia law and the definitions that Virginia has already in the code for what a state of nudity is and also what sexual conduct is according to Virginia law. And essentially what it does is this law comports and adds in a prong to Virginia child pornography, the definition of Virginia child pornography, that comports to the Miller standard, which is the definition of obscenity that is a well-trodden path of constitutionality. So there was some reference by Senator Perry to the Ashcroft decision when we were last before this body. And in Ashcroft, they analyzed whether the original federal statute would be constitutional. And the basic decision was there either needs to be a actual child under this other Supreme Court case called Ferber, which Virginia law outlaws currently and includes in its definition of child pornography, or under the Miller standard, the material has to be obscene, meaning that it appeals to the prurient interest, it is, objectively offensive and offends community standards, and then third, there's no redeeming value to it. So it can't be a Renaissance painting or something like that. So the amended language essentially includes artificially generated images that also would not have constitutional protection under the Miller obscenity standard. So it is 100% constitutional and well-trodden paths of constitution.
Here's my question, sir, and maybe Taylor, Steve can answer this. So how does suppose you have a case where, say, the age is close, and it's a AI generated minor. How do you determine whether or not the AI generated minor is underage or not? Is that just going to be up to the jury as whether it looks like a 17-year-old? I mean,
correct. The most egregious forms of child pornography are the prepubescent forms. I mean,
sure.
In my limited experience, you're talking about people that are 5, 6 years old. That
okay, but so you're saying it'd be a jury question as to whether or not that picture.
Mr. Chairman.
Yes, Senator Perry.
I mean, it's going to be an element of the offense, right? We always ran into this issue whenever you have images where they could be 17, they could be 18, and you don't really know. It's something that the Commonwealth would have to prove beyond a reasonable doubt that that person was under the age. If the jury or the judge has a question about whether or not the person is, then guess what? It's a not guilty. So it just gets passed on. It's like any other element of the offense. So those cases are the hardest to prosecute unless we know for sure.
And that's the way it exists.
Senator Perry, but right now, because we don't have the AI thing, you have to actually prove the child was on the registry, and we know what the birthday was at the moment the picture was taken, right?
We have to be able to prove that they are under the age of 18. So that could come about in a variety of ways. Sometimes that's through NCMEC, tracking them down. Sometimes it's because we have an identified minor. Sometimes it's because we bring in forensic nurses to be like, see these visual characteristics of this child. They are consistent with a prepubescent child and things like that. Short of that, I've talked to plenty of forensic nurses who, even when we suspect that the child is, closer to 16 or something like that, we still can't move forward on the case because they just can't say definitively, yes, this is a child that is under the age of 18. I believe this statute would work in exactly the same way. The elements still exist. You still have to prove it.
Okay. Does anybody else in the committee have any questions? I think you do. We've already taken, I think, public testimony on this, so we don't need to talk at length about it. Senator, was that a motion?
Yes.
Is there any other questions? Nothing? Counsel, anything to add? No.
It might be helpful for the committee to recall that any material that is obscene is unlawful. And so if you have a visual material that depicts an 18-year-old or a 20-year-old or 30-year-old engaging in something that is defined as obscene, that's still reachable by the criminal law. And so hence this new clause adds in the requirement that it be obscene, which is different from the current law, which is simply sexually explicit. You can criminalize sexually explicit visual images if the person involved is under 18. That's a lower standard than obscenity. But if the material is obscene, which this clause requires, then you can criminalize regardless of age.
Okay, thanks, Steve. Senator, I think it was Openshame moved, McDougall seconded to report the bill and refer it to Finance. Any further discussion? Okay, clerk will open the roll.
Ayes 15, no zero.
Thank you very much, Mr. Chair and members of the committee.
Yeah, bill reports. Thank you, Senator Durant. Reeves, I think you're up next. Reeves, you got 659, right?
I do, Mr. Chairman.
Do you have a substitute?
No.
No sub? Okay.
Mr. Chairman, members of the committee, working with former Senator Carrico, who represents the state police, this bill that's before the committee will alter the way that dismissals, demotions, suspensions, and transfer hearings are conducted for law enforcement officers. Under the current code, an advisory panel of 3 individuals is put together, all by the department, so it's weighted heavily on the department and not so much on the individual going through the hearing. What this bill will do is it'll choose one of those out of the 3-member panel. One is selected by the grievance, one by the agency head, and it'll expand it to 4. And finally, the 2 initial selectees is put together by the department. This bill will require a 3rd panel member be from a different law enforcement agency, someone outside the department. Under the current code, if the initial 2 selectees cannot agree on the 3rd member, a circuit court judge from the agency's judicial circuit selects the 3rd member. Under this bill, if the initial 2 selectees cannot agree on the 3rd member, a circuit court judge from the judicial circuit in which the grievance arose selects the 3rd member. It requires all law enforcement agencies to provide all information related to the initial grievance unless they can provide clear reasoning why it should not be shared. Mr. Chairman, under the current code, the hearing panel simply provides a recommendation to the agency. This bill would give the hearing panel decision-making power over the appeal upon majority consensus. It'll also allow either the grievant or the officer to file an appeal within 30 days of the panel decision. The appeal is handled by the clerk of the judicial circuit in which the grievance originally arose, and the court sitting without jury may uphold, reverse, or modify the decision. And Senator Carrico can elaborate more on how this came about. Bill?
All right, why don't we set it to 5 and 5, MJ?
Mr.
Welcome,
Chairman,
Senator.
members of the committee, Bill Carrico with Virginia State Police Association. This was brought on behalf of our association, which is 50 years old this year. We advocate for our troopers for pay and better working conditions, and 46 years ago, the State Police Association was very instrumental in putting forward the Police Officers Guaranteed Procedure Act within the Bill of Rights, the Police Officers Bill of Rights, to allow for fair administrative hearings. Fast forward 46 years, this procedure is not used very often, or if any, because this is heavily weighted towards the agency, and all we're doing is taking that 3-member panel and having one from outside to sit on that panel and make it binding. We began to look at this process and identified some of the things that were wrong with it. It doesn't change current law. It leaves the panel the way it is. It just makes it, it does change current law. It just makes it binding, and it adds that outside person to that panel. To explain further, our general counsel for the association is here, and he'll give you a background on that because he's the one that handles all of our criminal, civil, and administrative matters for our members of the state police.
Thank you. Come on up.
If there's anyone online that would like to speak in favor, raise your hand.
Good morning, Mr. Chair, members of the committee. David Oswinkle with the Virginia State Police Association. This proposal does not create a new grievance procedure. That procedure is already in place under the Procedural Guarantee Act. What it does do is it calls for the Procedural Guarantee Act to provide a guaranteed resolution for officer grievances. It only applies to discipline where an officer is fired, demoted, transferred, or suspended for punitive reasons. This is current law, and this bill will seek to improve the process, which currently does not provide sufficient resolution for employee grievances or to ensure due process. The bill provides slight changes to the composition of the panel. As was mentioned, one member will be from outside the agency. This is designed to lessen internal pressure on the panel members and to provide some transparency. The panel decision will be binding under the proposal. This is designed to, again, ensure due process and make it meaningful. Officers currently do not use the process because the agency does not have to abide by the recommendation. If the officer chooses to proceed under 9.1504, he or she is precluded from accessing any other method to address the grievance. That includes both local and state grievance procedure. Again, all of this is current law. And without a binding decision, there's no true due process, essentially allowing the agency to do whatever it chooses since there's no recourse. The changes allow for access to information related to the offense. This access is reasonable for an employee to have an opportunity to defend against the charges. It's arguable that the code already provides access to that information with the language that they have notice of the charges and the basis therefore. Allowing access to information will not inhibit an agency's ability to elicit information from employee witnesses through the internal affairs process. And lastly, the bill provides for an appeal process on matters of law to ensure that it is enforced and that due process is firm. It is of note that under current law, sheriffs are excluded from this. That would remain going forward. And the measure will not interrupt the decertification process. It's a process that stands on its own with its own standards. Thank you.
So I got a couple questions. So does this bill apply to all law enforcement agencies or just state responsible ones?
All law enforcement officers that are eligible and would choose to proceed under 9.1504.
Okay.
Except for sheriffs.
Right. So a locality, if a locality has a collective bargaining contract, if a local police department union has a collective bargaining contract with a locality, they can negotiate a different process than this if they choose to, right?
That's correct.
Okay. And if this bill were not to pass, an aggrieved officer still has the right to appeal a decision to the circuit court, right?
They could.
Okay. All right. So, okay. I don't have any other questions right now. Is it Senator Boysko?
Thank you, Mr. Chair. Question for the patron or the witnesses.
Sure.
Senator Reeves, Mr. Chair, Senator Reeves, would you be able to help us understand how many individual officers have been disciplined and why we need this bill? Like how many have been disciplined and then the decision has been changed, or they felt that it was unfair? Could you give us a little bit more insight into that, please?
Senator Sherwill, Delegate or Senator Boysko, I brought this on behalf of the state police. I can't speak to the whole state as a whole. I know when I was in Prince William, it happened all the time. We had quite a few issues where officers had to go through the circuit court to find resolution. I'm sure there's some data out there from DCJS possibly, but I'd turn to Senator Carrico and maybe he can talk about the state police as a whole.
Mr. Chair, from 1978 till now, we don't have numbers as who used this process, because you can also use, and most of our members, because of the way that this is weighted, uses the state grievance procedure instead of this. And so when we were looking at this, because it's not used, and I came to work for the state police in 1985, and I can't tell you one person that used it. Now, I didn't ever have to use it, thank God, but it's there. It's in the code, but it is weighted heavily on the department side because they pick the members. The grievant picks one, but it's from the department, and it's not binding, so therefore it's just a recommendation, and they usually migrate towards the state grievance procedure. I can't give you an exact number. We may be able to get it, but I can't tell you.
Okay, why don't we move to opposition really quick? Is there anybody here in opposition to the bill?
If there's anyone online that would like to speak in opposition,
I'm sorry,
please raise your hand.
is there anybody in support online either? Nobody? Okay, I'll just let the committees know. I got a lengthy email from the chiefs of police saying they have significant opposition to this, although they don't seem to be here. Okay, nobody's in opposition? Okay, is there a motion? Okay, it's been moved by somebody down there and seconded by Peak, I think. Stanley moves, Peak seconds that the bill be reported and re-referred to finance. Clerk will open the roll.
Mr. Chairman, should we be successful, I'd just let you know, I've spoken with Dana as well, so we're trying to find a happy medium there too. Should it report out?
Okay.
Ayes 5, noes 9, or 8, excuse me.
Weird. Okay.
Thank you, Mr. Chairman.
Okay. Thank you. I don't know why the chiefs didn't come today. I got a long email from them about it. Who's next? Is there anybody else out there? Evan. Senator Evan, I told everybody at the beginning of the meeting, you have a finance impact bill. Okay. So yeah, batter up.
This is SB 364.
Okay, Senator Evan, I think you have a substitute. Is that right?
Yeah, there is a substitute, and I apologize. I sent it to you all late last night.
Okay. Senator Deeds moves. Senator Boysko moves to adopt the substitute. All those in favor say aye. Aye. Anybody opposed? Okay, the substitute is before us. I believe it's in everybody's packet. Is that right? Taylor, Sabrina? Yeah, you got it? Okay. The substitute's substantially different from the bill that was filed, so everybody needs to make sure you look at it.
Yeah, maybe we should just walk through it quickly. What the bill does is it adds to the list of protected voters, election officials, or employees of election officials, but the meat of the bill is about the penalties for intimidation and threats towards presidential electors and officers of election. Basically, right now, it's a crime to interfere with an officer of an election at a polling place or at a voter satellite office or at another location used for voting purposes. That's a class 5 felony, but it's not that's for officers of election. But I wanted to make it that officials and employees of election officials who administer elections are also covered on that. And then I also brought in presidential electors for president and vice president, both who threatens them or interferes with their duties is a class 5 felony, or threatens to kill them or do bodily injury, a class 6 felony. And then importantly, it allows for civil action for violation if you're a victim of the conduct that constitutes a felony or misdemeanor in this title, or 18.2, that you should be entitled to file a civil action to recover compensatory damages. And I think everyone up here knows the reasoning for this bill is that there's been violent and relentless threats against election officials and poll workers as a trend in recent years. And a survey found that 1 in 3 local election officials felt unsafe in their jobs or due to their jobs. So what we're trying to do is just make sure that there are penalties not just for interfering with an election on the day of the election with election officials in the polling place, but with people who administer elections regardless.
Let me see if I can crystallize this for the committee. The bill basically, lines 47 and 48, allow electors and former election officials or election employees to get their address off the voter registration list so that people can't find out where they live. And the second thing the bill does is it adds to the existing statute about threatening election officers. It broadens that to election officials, employees, and then it creates a new crime for bribery, intimidation, threats, coercion in violation of against electors, presidential electors, right? And then it also creates a new felony for threatening to kill or do bodily injury, intimidate, harass, coerce, etc. An elector, and then it creates a civil action for anybody who's a victim of a crime, and it turns out that the crime was directed at them because of their status as an elector or election official or an election employee or election worker, right?
That's correct. And a key word on line 64 is because they're an elector, not just because you happen to threaten an elector, but if it's because they're an elector, yes.
Got it. Okay. Does the committee understand the bill? Okay, are there any questions for the patron? Senator Peake.
Yes, thank you, Mr. Chair. And it might be for the patron, it might be for Mr. Benjamin. Mr. Benjamin, I believe we just passed a bill out of this body. It's going to the Senate floor, reducing the penalty for assault and battery against law enforcement officers. Does this, we do not have one that's doing away with mandatory minimum on law enforcement officers. Now, affirmative defense, is the penalty for that going to be higher? Is the penalty for this going to be higher than the penalty for assault on a law enforcement officer? This is a class 5 felony, is that correct?
I think the council can answer that, but it depends. I think class 5 felony, it looks like, is for an elector, and a class 6 felony for...
Mr. Chairman, the class 5 felony applies to someone... Mr. Chairman, the class 5 felony applies to someone who interferes with the actual administration of an election. The class 6 felony is when somebody, by threats of bodily injury, intentionally tries to intimidate, coerce, or harass another because of their status. That's a class 6 felony. I think that the current penalty for assault on a law enforcement officer is a class 6 felony.
And so this makes it a Class 5 felony.
No. The Class 5 is for something more than assault. It's for interfering with an election.
To hinder or
Actual interference.
prevent. Is that, or does the substitute change that? So I'm looking at the summary. The
Mr. Chairman,
a Class
Senator
5
Peake,
felony.
it does not. Current law classifies this conduct as a Class 5 felony.
Senator Peake?
He said it does not?
He said current law is
Currently,
already
it
a
does.
Class 5
It
felony.
already does, okay. Thank you.
Okay. Any other questions for Senator Eben? Looks like McDougall has one.
So, Mr. Deeds, but I don't see any affirmative defenses in here. So if somebody, the same affirmative defenses that we would have for law enforcement are not included in this statute?
Mr. Chairman, there are no affirmative defenses in this statute.
Right. I'm not sure.
This is a little bit different. This is because of their status in administering an election that you would go after someone because they're an election official. It's not about touching someone or it's threatening to kill or do bodily injury or to interfere with them because of their status.
Okay, hold on. Is there another? Senator McDougall and Senator Boysko, I think.
Mr. Chairman, I don't think that's what it says. It doesn't have to be a threat to do harm or bodily injury.
Well,
it says intimidation.
Okay,
Senator
you're
Eben.
line 59. I'm sorry, Mr. Chairman.
Go ahead, Senator Eben. You want to respond to that?
The key is that you're doing this because someone is trying to fulfill their duty to administer our elections on line 61 or on line 65 if their status as an elector.
Senator McDougall.
Mr. Chairman, I don't know that when we have a law enforcement officer that's trying to protect the public and arrest somebody, there's an affirmative defense there, and this could be exactly the same situation, and a person that has been diagnosed with autism or another one of the affirmative defense factors has no ability to exercise that affirmative defense. So I don't see the difference.
Well, it's a different bill, a different situation in that I don't think we have people getting in heated situations on voting.
Yes, Senator, there's not many
who are
election
autistic.
workers that are physically grabbing people to control them like they would in police situations. Senator Boysko has a question, I think she had one to follow up on this too.
Thank you, Mr. Chair. I have a question for the patron. Senator Evans, would you be able to explain to us why you brought this bill? Is there anything that's happened in the past, say, 4 years that made you think that maybe we needed to change the policy around this?
Yeah, thank you for asking. I have pages of the sudden violent treatment of election workers changing lives for public servants across the country. In Philadelphia, one Philadelphia election official described nightmares disturbing his 3-year-old after a barrage of threats brought police to guard the family home. A Georgia official and his wife canceled visits from their grandchildren to protect them from angry protesters at their home. A New Mexico official fled her home for several weeks. One election official in Detroit who now walks with a gun compared the onslaught against election workers to the attack on the U.S. Capitol. She said, except they're coming to our homes. These are people who are public servants doing their duty, and this just says that you cannot interfere with them doing their duty or intimidate them because of their duty. These are people, we need more people to be election officials, and we just need protections for them. Thank you.
Okay, thank you, Senator. Senator Salim.
Thank you, Mr. Chairman. Thank you, Senator Evans, for bringing this specific bill up. To add on to what Senator Boysko has brought up, over the last 4 or maybe 5 years, we have seen an increase of not only threats but violence in the sense against election workers. In our Commonwealth and in the nation, we do have shortage of election workers, and they should not be in fear that if they sign up to do something to essentially help democracy in this case, they should be threatened. Or, I had an incident, one of my current employees that are working for me who was an election officer in the past, and one of his coworkers, somebody followed them to their residents after an election has taken place. So those are the things this bill is trying to ensure that these don't happen in the future. And we're talking about the fact that our elections continue to get attacked. And so I do say thank you, Senator Evan, for bringing this up, and I will be supporting this bill.
Thank you.
Okay, thanks. Are there any other questions to the patron? Okay, so why don't we go to support and opposition, 5 and 5, okay?
Mr. Chairman.
Yeah, Senator Stewart.
I'm just wondering what the sense of the patron or the committee is to amend this bill to include judges in it, and then I could support it. You know, for some time now, we've been trying to get some protection from our judges who administer our judicial system, who are being intimidated and harassed and picketing out in front of their homes. And I'm just wondering if the committee would consider that amendment to include them in this protection as well.
Senator, would you consider that a friendly amendment?
Well, as long as it's the title of the bill is about elections and protection of elections, electors and election officials. I don't mind anything to protect judges, but on the fly, I'm concerned about just taking this apart. It sounds like a good idea for another bill.
Okay, thank you, Senator. Can we go to support and opposition?
If there's anyone
Maybe we'll
online
see
that
a
would
floor
like to
amendment.
speak in favor, raise your hand.
Mr. Chair, members of the committee, Tram Wynn with New Virginia Majority, thank you, Senator Eben, for carrying this bill. As the patron and others have said, this has become an increasing threat across the country. It's become so bad, in fact, that the Department of Justice has partnered with the FBI and the Department of Homeland Security to create a task force just to address this issue. I don't know if any other registrars are here today, but in the House, when this bill, a similar bill was heard, many registrars came up and said that they indeed have been receiving threats in the last year here in Virginia. So this isn't a problem just in other places. It's happening here in our state, and we really need to protect these folks. Thank you.
Talia Mallory with the Virginia NAACP, and we support the bill.
Thank you. Okay, anybody online?
Mr. Chair, there's one person online that would like to speak. Joan Port, please unmute and make sure your camera's on.
Thank you very much. League of Women Voters of Virginia urges you to report this bill. The bill offers much needed protections to the people who run Virginia elections before, during, and after the elections. The bill extends the right to civil action as well as protection against crimes, including doxing and swatting, to current and former officials alike. In other states, election officials, and frankly, even here in Virginia, election officials and even members of our league have been subjected to traumas for simply trying to do their jobs. We've been harassed just trying to register people to vote in a nonpartisan fashion. Nationwide, nearly 1 in 3 has been harassed, abused, or threatened. 1 in 5 is worried about being physically assaulted on their job. As we've heard, many experienced professionals have abandoned this field. We are in need of more people to step up and do this. And if we don't, the effective election administration will be in jeopardy. We need to protect our election officials. It's the least we can do for the people who serve the Commonwealth. Thank you.
Thank you. Can we reset the clock, go to opposition? Anybody opposed to the bill? Come on up.
If there's anyone online that would like to speak in opposition, please raise your hand.
I'm speaking in opposition.
Go ahead, yep.
Good morning. My name is Nancy Smith, and I'm with Middle Resolution PAC. This bill will
Senator
effectively...
Smith, where are you from?
Henrico County.
Thank you.
This bill will effectively silence the constitutionally protected speech of citizens of Virginia. It will intimidate volunteers for fear of making a comment or asking an innocent question during the administration of an election. As a career public employee, I was protected under the law from harassment and threats. Registrars and their staff have the same protections that I did. If they are not seeking those protections and filing charges with local authorities, as well as notifying their local governing boards, they should do so. That is their obligation. The state legislature is providing a carve-out for certain citizens without a body of evidence coming from local authorities. Unless I'm mistaken, we are not in Detroit, Georgia, New Mexico, or Pennsylvania, and I resent the senator's comment about this starting 4 years ago. I urge you to vote against Senate Bill 364.
Thank you. Council, could you all answer whether or not it's threatening to hurt or harm or kill somebody is constitutionally protected speech?
It is not constitutionally protected speech, Mr. Chairman.
Great, thank you. Is there anybody else online opposed to the bill?
Mr. Chair, there are 3 people that would like to speak. Christine Brim, please unmute and make sure your camera's on.
Hopefully you can see me. I'm sorry, is my camera on?
Yes, please go ahead with your testimony.
Turn your camera
Okay,
on.
fine.
And your camera needs to be on too.
I'm trying to turn it on, I'm sorry. I don't know how to do that, I guess. Make me a presenter, make a presenter.
You want me to go to the next person while she works on her camera?
SB 364, I'm from Fairfax.
Okay, thank you, Ms. Brown. Let's go to the next one.
Aaron Joyce, please unmute and make sure your camera's on.
Thank you, Mr. Chairman. Thank you, committee members. I speak to you today, I'm from Alexandria. I speak to you today as a trained elections officer for Fairfax County. So I'm one of the people that you want to protect with this hate crime bill. And I find it to be way too over the top. And I also challenge anybody who cites this stat about 1 in 3 election workers say they've faced threats. That is a distortion of the survey by the Brennan Center. But it also did find that 77% of all the election officers and election workers that they surveyed did not know anybody who has been threatened. I find that this would not only chill participation for election officers at a time when there is a critical shortage of election officers. I'm also particularly concerned about the carve-out for allowing social media companies to use judgment to decide what is hate speech at a time when we're looking at government that is working in collusion with social media companies to suppress the views of conservatives or speech that is disfavored. We all understand that no one has a right to threaten violence as free speech, but I think this bill goes way too far, and I urge the committee members to vote no. Thank you. And I also want to thank the chairman for taking my call and hearing my concerns. I appreciate his time. Thank you.
Always happy to listen to a constituent, and thanks for reaching out. I think the bill has been substantially narrowed since the one that was introduced. But thanks for calling. So who's next?
Lindsay, please unmute and make sure your camera's on.
Thank you, Chairman and members of the committee. My name is Lindsay Zaya. I live in Buena Vista, Virginia, and I'm with Virginia Institute Action. We oppose this bill for the harm it could do to citizens properly trying to exercise their right to engage in the election processes if false assertions were to be made against them, or magnified further than the details of the situation. While we condemn ugly behavior by anyone, especially against individuals serving our public in an elections capacity, we want everyone to be safe, including election officials, voters, and poll observers. And if this bill were to pass, could asking polite questions in a proper manner be considered intimidating? We should be able to engage with election officials in an appropriate, polite, and civil manner, asking questions, and we're concerned that this could be put in jeopardy by passage of this bill. And for these reasons, we ask you to please oppose SB 364. Thank you.
Thank you. I think that's it, right? Okay. Testimony's closed. Are there any other questions or comments or anything for Senator Evans?
Mr. Chairman.
Oh, sorry, Counsel. Yeah.
I just wanted to clarify in response to Senator Stewart's excellent suggestion that judges be equally protected. I wanted to point out to the committee that under existing law, the what we call the resisting arrest statute, 18.2-460, subsection C, already covers judges and magistrates and jurors and prosecutors, providing that if any person by the same conduct, by threats of bodily harm or force, knowingly attempts to intimidate a judge, etc., that is a Class 5 felony, a more serious punishment than this bill provides for election officials.
Okay.
Mr. Chairman, I also wanted to point out, because of the free speech qualms that have been raised, that this bill, the substitute, which may not be before members of the public, is written very tightly to ensure that it does not infringe on protected speech. And so in each instance, the bill requires that the speech, that the conduct bribery, intimidation, threats, coercion be made willfully and intentionally, which means deliberately, and that they place somebody. When you see the word intimidation, that means that it is so consequential that it places somebody in reasonable fear of bodily harm. My point is that the bill was written to ensure that there was no accidental violations or ambiguity that could cause somebody exercising their free speech rights to be threatened with prosecution.
Counsel, I think the original bill made generic harassment or intimidation subject to a civil action, and this is substantially narrowed in that you have to show a violation of a crime in order to have the right to obtain civil relief. Is that right?
That's correct, Mr. Chairman.
Okay. Okay. Any other questions for Senator Eben? Senator Eben, you want to have a really quick final word, or are you good to go?
I'll let you all vote, but I just want to say that this is narrowed from what was introduced. It doesn't involve hate crimes any longer, and there's no prohibition on anyone asking a question of an election official. Thank you.
Okay.
Mr. Chairman.
Okay, Senator Obenchain.
So I'm looking at line 63 of the bill, and it says, any person who intentionally intimidates another because of his current status as an election official.
By threats or to do bodily injury?
No.
By threats to kill or do bodily injury? No. All right.
I don't believe that's what it says. Any person who, by threats or attempts to intimidate, force,
to kill,
right?
And willful intimidation.
So if somebody is demanding that an election official comply with the law and intimidates that election official who is not complying with the law, would they be guilty of this?
Mr. Chairman,
Senator
the answer is
Mr. Benjamin.
They would be guilty only if they made threats to kill or do bodily injury.
I'm going to kick
Senator
your butt
Benjamin.
if you don't comply with the law.
Mr. Chairman.
Yeah. Somebody else. Senator Stewart.
Mr. Chairman, again, I'm just a dumb country lawyer, but there's an or there. Any person by threats to kill or do bodily injury willfully and intentionally intimidates, coerces, or harasses, or intimidate, or attempts to intimidate. And so that is an or. It does not include those words, threats to kill or do bodily injury. I disagree.
Okay.
And so if you are just adamant in your position without threatening to kill, you could be guilty of a Class 5 felony. And do we really want to subject people who are going to vote to do that, to prosecution of a felony? If they're expressing their opinion?
Mr. Chairman.
Mr. Benjamin.
Respectfully, I disagree.
Me too.
And maintain that on line 63, the clause, by threats to kill or to do bodily injury, modifies everything that follows.
Right. It has to be a threat to kill or do bodily injury. I'm going to kick your butt if you don't follow the law. It's something that shouldn't be said in a polling place. I'm sorry. Any other questions? It's been moved and seconded by Senator Deeds, seconded by Senator Boysko. We report and refer the bill to finance. Any further debate? Okay. The clerk will open the roll.
Ayes 7, no 6, abstentions 2.
Okay, the bill reports refers to finance. Thank you, Senator Evan. All right, folks, we have, I think, 7 to go. Finance impacts. Oh, Pillion's here.
Pillion is here.
For xylazine. Tell us all about...
Correctly. That's perfect pronunciation. Yeah.
Or trank.
Yeah.
Right, trank, right?
It is trank. How'd you know that? We need to talk.
I Googled it to try and figure out what xylazine is. So.
All right, Mr. Chairman, xylazine is an FDA
do you have
approved.
A sub? You don't have a sub, right?
I'm not. It's an FDA approved animal tranquilizer for veterinarian use that we've been seeing it diverted. So in April, the Office of National Drug Policy officially designated xylazine as an emerging threat in the U.S. due to its illicit use. Xylazine taken with an opioid, especially dangerous since the drugs together slow down breathing and can cause someone to stop breathing completely. You can reverse an opioid with naloxone, but xylazine you cannot. So this bill is similar to the legislation currently pending before Congress, which would criminalize possession and distribution of xylazine for human consumption. There is an exemption for veterinary use, which we've worked with the Farm Bureau to get that in there, which again is FDA approved, and there is a budget amendment that's associated with this piece of legislation.
Okay, Ms. May, why do we need to create a whole new section for this instead of throwing it in like on the schedule or something? Or is it already on the schedule? Why did we have to have a whole separate statute for this one drug?
Mr. Chair, and this, I believe the introduced bill did add it to the schedule and would have made it a Schedule 3 substance. The substitute that was reported to us from Ed and Health changed it to kind of just be the standalone. I may defer to the patron, but my assumption would be there would be additional consequences with making it a Schedule 3, and we just wanted to, yeah.
Mr. Chair, she's exactly correct. That's we did it this way so the veterinarians would still have use of it. And there was a huge concern because without them this is the one tranquilizer they can use to do large animal work.
Okay. All right. Any questions for the senator? Okay. Is there anybody in opposition to the bill?
If there's anyone online that would like to speak in opposition, raise your hand.
Okay, it's been moved by Senator Stewart, seconded by Obenshain, and we refer the bill to finance. Clerk will open the roll.
Thank you, Mr. Chairman.
Ayes 15, no zero.
Thank you, Senator. Is anybody else out there behind the podium? No, okay. So, why don't we go to Stanley? I see some people out there that want to talk, so why don't we go to Senator, let's go to 493, Med-Mal. And Senator, you have a sub or anything, or going off the original bill? Yep.
Morning, Mr. Chairman, members of the committee. Senate Bill 493 before you today attempts to right a wrong that's been going on here in the Commonwealth of Virginia, and in particular as it pertains to the...
Lean into that mic.
That's the first time I've ever heard that in my life.
I bet it is.
You actually want to listen to me? This is great. Ladies and gentlemen, members of the committee, what we have here is we have what's called a medical malpractice cap, which limits damages and awards, at least at this point, to $2.6 million. There is an increase every year of $50,000, which it goes without saying it's incremental at best. It's an agreement that the trial lawyers and the doctors came up with a long time ago, I think 2010, 2011. None of us here are part of that, and quite frankly, what we're seeing is that there's some inequities that are resulting from the cap and its limitations. This bill, in its essence, seeks to actually lift the cap for 10 years and under. Studies have demonstrated that where malpractice has occurred against those children, it's not a great number of cases at all, but even nationwide, that those tend to be more severe. They're usually brain injury cases. And quite frankly, the care of that child from the age of, let's say, a toddler to the age of 10, usually because they're developing physically, mentally, and otherwise, physiologically, that the damages and the cost of those damages is much greater than even the maximum of the cap. If you take what the attorneys take and you take out the expenses to litigate, usually the parents are left with a very small amount, which then results, ladies and gentlemen of this committee, in usually us picking up the tab in the difference. Because when they can't afford medication, they can't afford insurance, they're uninsurable, then Medicaid picks it up, and it is the taxpayer that ends up paying. This is a very thin repeal of the medical malpractice cap because children are our most important resource. You're going to hear, and I've handed you out a packet, to debunk the myths that you're going to hear from the doctors who may come before you today who say, this is going to drive up insurance. This is going to drive people out of the pediatric practice. And quite frankly, those have been proven not to be the case. There were, I believe, 4 myths I wrote down here. that I think we can all pay attention to. Myth number one, that modifying the cap is going to lead to excessive malpractice claims. This is actually the information that we've pulled off on Virginia. 3,250 claims or judgments from 2005 to 23 have been paid. Out of those, 90% were less than $1 million. And the other thing is when we're dealing with catastrophic injuries to children, and I talked about those expenses, what's the value of a child who then dies at the hands of the negligence of the doctor? And so, do we put a price tag on it? Is there any incentive on behalf of the insurance companies to do something about it? Now, you'll hear from insurance companies that may say this is going to put insurers out of business. If you look on page 2, I did some research. Insurers in Virginia, they make money hand over fist. From 2008 to 22, they collected $3.14 billion in medical malpractice insurance premiums. They paid out $1.56 billion in claims and or direct defense costs and expenses. That's to their own lawyers. So that left them with a profit during that time of $1.58 billion during that time, after everything was paid. And so that's not true. Myth number 3, without caps, medical malpractice insurance premiums will skyrocket. What we've seen is that there is a higher amount and rate in Washington, D.C., Maryland, other areas, and the premiums are right in line with where they are in the Commonwealth of Virginia. A study in 2016 by Robert Hunter of FIA, he was federal insurance administrator under Carter and Ford, said, this data doesn't support any conclusion that limiting patients' legal rights, including capping damages, will result or results in lower premiums for doctors. So there is no correlation there. And then number 4, caps simplify and add efficiency to the legal process. Well, quite frankly, it creates an uneven playing field, and here's why. And I'm not a medical malpractice lawyer. I'm just a country lawyer like Senator Stewart. But it seems to me, from the ones that I talked to, is that there is no incentive to settle these cases when there are significant injuries, because they know, the insurance company knows, that it's a top-line number. It never changes. So what they usually do is wait out the plaintiff, who sometimes is ill-equipped, doesn't have the time, the resources, the money to play the long game like these insurance companies do, who pay their lawyers to absolutely not make offers, play it out, elongate the process. It creates an uneven playing field and limiting the risk of loss, because regardless of the verdict, the insurer will not have to pay anything more than the cap. And that other point is, insurance companies spend $50,000 fighting claims for every $100,000 in claims paid. So what we're talking about here, and especially when you look at the factors, children 10 and under, and people may ask, well, why did I pick 10 and under? Because that's the area, and toddlers, that usually when they have an injury caused by medical malpractice is catastrophic or death, most affecting the brain. Over 50% of those affect the brain, and you know how that functions, and that is why this becomes very insufficient as the child grows. That money is short and does not address the problem. This is not a full repeal, but I will tell you there is no reason why we have these caps. I've been of the opinion of that. You'll see also too in the brochure that I gave you a spreadsheet of all how many medical malpractice payments have been in Virginia, and this comes from the National Practitioner Data Bank. Of 2 million or more total from 2005 to 23, 42. 42. So this is not going to create some depletion of resources by insurance companies. It's not going to drive doctors out of the business. These are for rare occasions. And of those 42 that were in excess of 2 million, most of them were higher judgments, but were then reduced by the cap. I then give to you, and you will meet this family today, Carson McRae, who lost his 2-year-old. There is his op-ed that he did, and this is how I met him, when he talked about the death of Artemis, his 2-year-old child, at the hands of the malpractice of a nurse, a traveling nurse. What's a 2-year-old boy with life all in front of him, who was merely getting supposedly an injection for an appendicitis of Tylenol and was poisoned? What's his life worth? The insurance companies would say $2.6 million, period. And by the way, we'll sweat them out until they give up. And then on the last one, when I first brought this, Mr. Chairman, the story of Nancy, and who had $9.3 million in expenses, a traumatic brain injury when she went in for lower back surgery, and yet, and the jury awarded her those damages, and yet, she was limited, I think, to $2.3 million at the time.
Yep, I think she was my constituent, so.
Yes. So that's the bill, and the purpose, and the reason why all of us can vote for this.
Thank you, Senator. Hey, Senator Rome, we still got 7 finance bills to go. Just want to make sure you knew. Any questions for Senator Stanley? Senator Boysko.
Excuse me.
Senator Stanley, I know you brought this bill several times before our committee. Last year, I
think it's been once, and it wasn't limited to 10-year-olds. But
has it only been once? It feels like it's
Mr. Chair,
been a million
this bill
times.
has never been in this form ever.
Okay.
I brought one for catastrophic injuries that would have addressed Nancy's situation, which
Yeah.
is also a very small percentage, but never like this.
Mr. Chair, just wanted to
Yeah,
get
go
to
ahead.
my point.
Okay.
Last year, when you brought a bill that was similar to this, we talked about that we were going to pull some stakeholders together and talk about how do we deal with those most grievous injuries where someone is left and they're not going to be able to care for their loved one. Did that take place?
Mr. Chairman, I regret to tell the senator, my friend, no. No.
Thank you.
Okay.
I tried.
Thanks. Any other questions, Senator Stanley? Okay, let's set it 5 and 5 because I know we have a lot of people here to testify to this.
Mr. Chair,
Yeah.
and the people that I know are coming, or Mr. McCrae, and I believe Mr. Camerata.
Okay, come on up. Set the timer to 5 and 5.
If there's anyone online that would like to speak in favor, please raise your hand.
My name is Carson McCrae. My wife Kaylee is in the back. We're from Warrenton, Virginia. And this is Artemis, our son. He loved adventure and dragons and cats and jumping off the highest platform he could find. He was our world and the world was his. Artemis died only 2 years old due to medical malpractice in November of 2022. He complained of stomach pain, and we took him to the hospital where he was diagnosed with appendicitis. He charmed every nurse and doctor who met him, even helping a few medical students to learn how to conduct an ultrasound. They all left the room smiling. What should have been a basic and routine procedure turned into a living hell. While Artemis was in the ED, he was inadvertently given 1,000 milligrams of Tylenol when he should have been given 175. Artemis's liver failed, and the resulting swelling in his brain left us with an unimaginable decision. Do we try to drag our son through this to live out his life, unthinking, unfeeling, unsmiling, never knowing love or how to feed or clothe himself, or do we let him go? We chose the latter. Artemis died in my arms nearly 24 hours after his breathing tube was removed. We made the decision to let our son go rather than see him watch life go by from the sidelines. I assume many of you have children of your own. In the same situation, I would not blame any of you in the slightest if you brought your child home despite the coming hardships. Even when it was clear where the fault lies, Virginia's medical malpractice cap applies. Even when guilty parties accept responsibility and acknowledge that the cap is insufficient and insulting, the cap still applies. $2.6 million sounds like a lot of money, but if Artemis had lived as anyone in this room, I think that would have been nearly enough to keep him alive and comfortable for the rest of his life. Considering specialized home care, medications, therapy, lost wages, attorney fees, and so much more, I don't think you need me to do the math to know that $2.6 million is laughable. Artemis had his whole life ahead of him. Our laws are supposed to protect your constituents. The cap only protects medical facilities and companies who insure them from the repercussions of their actions. I do not want to see doctors under fire, unable to perform for fear of litigious patients. One of the people I respect most in this world is a doctor who did everything in his power to save Artemis's life well beyond the scope of his job. He celebrated the good news with us and cried with us at the bad. Most importantly, Virginia's cap endangers patients. If a hospital and their insurers know they will only ever have to pay $2.6 million, no matter how grievous the error, they are likely to become complacent. Artemis is gone. All the money in the world won't bring him back. We stand to gain nothing from this bill. But nobody should be denied the option to keep their child by their side. I cannot begin to describe the unending, unconditional love a parent feels for their child. That love is only intensified in loss. I wager no politician, no lawyer, or insurance expert, or doctor can look me in the eye and tell me what the life of my child is worth. I wouldn't dare tell you the worth of yours. Thank you.
Thank you for coming today, and sorry for your loss. Mr. Two more and minute 40, Mr. Camerata.
Good morning, Mr. Chairman. Thank you, and thank you to Senator Stanley, and good morning. I had the good fortune to represent Nancy, who was a friend and neighbor, and I had the misfortune to get a jury verdict that was not able to fully compensate Nancy for the uncontested damages that she faced and presented at the trial. The shortfall of the damages in and of itself after applying the cap was some $7 million. If we go back to first principles here, what type of system of justice do we have? We have a system of justice where there should be full accountability and responsibility for harms done. There should be a full and fair opportunity for people to have their grievances heard by a jury of their peers, our greatest right as Americans. And there should be an opportunity to trust the jury to get it right. And if the jury, on the off chance, doesn't get it right, well, there's always the judge that can make it right. I think, and I urge each of you to not be misled by the cries and the Chicken Little defense of the doctors that you'll hear soon. The sky is falling. We must do something to protect the doctors. Senator Stanley artfully and clearly identified the myths and the answer to those myths. And so I urge each of you to vote in favor of lifting the cap in this limited opportunity. Thank you.
Thank you. One more. We're out of time. Who you're with? What? Okay.
If I may, Les Bowers, attorney from Charlottesville, Virginia.
Can you
I
keep it
handle
to 30
almost
seconds?
exclusively medical malpractice cases in Virginia and North Carolina. I would say two things, given that much has already been said. In Virginia, there's no cap if a child is injured from a negligent car driver, tractor trailer driver, or a defective product. The sky hasn't fallen as to those defendants. The same is true and is proven to be true in other states as to healthcare providers who do not have the benefit of the cap. Secondly and finally, if the tortfeasor does not pay for the harms in this incredibly small class of plaintiffs, Medicaid will. And in the incredibly small number of cases that aren't in the birth injury fund, but are for children under the age of 10, Medicaid is footing the bill for 50, 60, 70 years for these patients in lieu of the increasingly conglomerated, private equity-owned, multi-billion-dollar healthcare industry, which there may be some odd examples, but even pediatricians, by and large, are part of this conglomerated healthcare industry. The harm should fall to the tortfeasor. Thank you.
Thank you. Okay. Now we'll go to opposed. MJ, can you set it for like 6 minutes, 30 seconds?
If there's anyone online that would like to speak in opposition, raise your hand.
Thank you, Mr. Chairman, members of the committee. I'm Scott Johnson, appearing before you as General Counsel for the Medical Society of Virginia. The first thing we all have to acknowledge is what you heard. Medical malpractice cases are emotional. It's not a single person in this room's heart doesn't go out to the gentleman and parent who testified.
Yeah.
It's not a single person in the room.
Senator Obenchain, question.
Scott, Senator Stanley said that after the bill was brought 2 years ago, I think, in response to Senator Boysko, that there were no follow-up discussions to try and get to the root of the issue. Is that true?
Mr. Chairman, Senator Obenchain, I know a letter was written to the Bureau of Insurance. I don't know of any meeting that took place. I know Mr. Barano and I from the Medical Society did drive down to Senator Stanley's office, not this fall, but actually the bill was brought 2 years ago. We went down there and met with Senator Stanley. Other than that, I don't know of any other meetings.
So there were, Mr. Chairman, so there were no efforts to try and address the underlying problem?
The only other thing that I know that I did, and I can't speak to what others did, is we asked Medicaid if Medicaid tracks or knows how many enrollees have had a malpractice case before they come to Medicaid. And the answer to that was no, they don't know that. Those are the two things that I did.
You done, Senator? Okay. Hey, go ahead, Scott, and continue.
So anyway, Mr. Chairman, I don't want you to think that we are cold-hearted. I don't want you to think doctors don't care. They care. In a malpractice case, the emotions are equally on a doctor. They're trying to do the right thing. They're equally on a nurse. They're trying to do the right thing. And so emotions are there. We have to acknowledge that. But I think it's important to note, on our medical malpractice cap, which we've had for a long time, it makes sure coverage is available. Coverage has changed. Sometimes it's purchased on the commercial market, but a lot of times physicians are being hired by hospitals, and the hospital is providing coverage through some type of self-insured plan. It's not lost on me today that you're asked to decide this issue in the shadow of Children's Hospital right there, and because that's going to get impacted by that. We've mentioned that our medical malpractice cap 3 times our Supreme Court has determined it's to be constitutional. We've not mentioned the fact that if a doctor or a nurse commits an act that's intentional or willful, it is not subject to the cap. Your unlimited liability if that is the case. We mentioned the birth injury fund. The birth injury fund was created at the same time the cap was, because that provides lifetime benefits. JLARC did a study that said the benefits under the birth injury fund far exceed the cap, and those benefits are full range on that piece of it. You've heard it said, I just want to show you the paper. In 2012, the Virginia Trial Lawyers Association and the Medical Society entered into an agreement that's given rise to the legislation that was passed by this body to increase the medical malpractice cap. I will tell you, you're not bound by this agreement. No General Assembly can bind another. But the Trial Lawyers Association, you will hear, stand with us in support. They honor their word. They honor this agreement as it goes forward. Some of you have asked, as we've gone around to meet with you, well, what about other states? Well, there is apples and oranges. In some other states, they don't have caps. In other states, doctors don't carry the limits of medical malpractice like they carry here. So what may happen in a state that is not too far south of us, a doctor may only carry $1 million in malpractice coverage. That gets paid, and if they can sue the hospital, they'll get additional money. And if that doesn't get paid, what happens is you've got a family with a judgment that can't be satisfied or paid. We don't want that to happen here in Virginia as it goes, because the costs shift to Medicaid. Nothing is free in health care. There's been no analysis done to say what would these claims, if they're taken out of the cap, what would that affect all the other med-mal claims, physician retention, recruitment, those type of things. If you forget everything that I say today, I ask you to look at Mars and Venus. All of these healthcare provider organizations unified in opposition to this bill, and the trial lawyers and the doctors honoring the agreement that was reached before. It's something to be said for that, and I'd ask you not to go forward with the bill, and I'll defer to the other folks behind me.
Okay, thank you. Next, we only have about 3 minutes left for this long line of people, so please be respectful of others' time.
Will do. Good morning, Mr. Chairman and members of the committee. My name is Dr. Sherry Barkin. I'm a practicing pediatrician and the physician-in-chief of the Children's Hospital of Richmond. You know that VCU Health is the largest safety net provider in the state, and we have significant concerns about the bill before you. This bill will increase premiums and decrease medical specialty workforce, but I'm here today because I want to caution you about the unintended but foreseeable negative consequences that this legislation could have on access to care. We're especially concerned about rural areas in the Commonwealth. VCU Health is immensely proud to fill the void as the only provider for labor and delivery services in rural Southside Virginia at CMH. We're also very proud to care for children with complex medical and surgical needs, such as those with congenital heart defects, as well as extreme prematurity. If this bill were to pass, health systems like ours would need to reconsider if services like this could be available. We know that access significantly impacts outcomes. For example, an extremely premature baby was born at CMH because we were there, VCU was there. Both the baby and this extremely premature infant was stabilized through the CHOR NICU team and transported safely here. Both mother and baby had a safe outcome. What if we hadn't have been here? As your dedicated state partner, we urge you to vote no on SB 493. Thank you.
Thank you. Next, we got 1 minute, 20 seconds. So,
Good morning, Mr. Chairman, members of the committee. I'm Dr. Harry Gawanter, and today I'm speaking on behalf of the Virginia Society of Rheumatology and the Virginia chapter of the American Academy of Pediatrics. SB 493 will directly target the pediatric specialty and any clinician who cares for children. If the costs and risks of being a pediatrician go up, we can expect Virginia medical students will look into less risky specialties, and experienced pediatricians may not choose to practice here. Virginia needs more pediatricians, not less. We rank behind D.C., Maryland, and North Carolina in the number of pediatricians per 100,000 children. I ask you to vote no on SB 493.
Thank you. Next.
Good morning. I'm Steve McCoy. I'm with Patient First. I'd like to address one of the myths that Senator Stanley mentioned. We practice in both Maryland and Virginia. We see over 1 million patients a year in Maryland. We see over 1 million patients a year in Virginia. In Maryland, we maintain $1 million of coverage for each of our providers. It costs 3 times as much as the $2.6 million of coverage that we maintain for our providers in Virginia. Please vote no on this bill.
Thank you.
Good morning. My name is Nancy Boykin. I am the Chief Nursing Officer at HCA Retreat Doctors Hospital. I believe this bill will create challenges for retaining and employing our physicians. In an already challenging healthcare system, I believe this will impact the care that we provide our patients, our community, and I oppose this bill. Thank you.
Thank you. Time's expired, so you all just come up and say who you're with.
Mr. Chair, members of the committee, Brent Rawlings for the Virginia Hospital and Healthcare Association. We oppose the legislation. We urge you to keep the cap in place and the sound policy behind it, keep costs low, protect our access to care, especially in rural and underserved areas. Thank you.
Thank you.
Mr. Chair, members of the committee, Mike Forehand with Innova Health System. For the reasons previously stated, we oppose the bill. Thank you.
Good morning. Keenan Caldwell with Centera Health, and we oppose as well.
B. Gonzalez with Riverside Health System and VPMA. We also oppose this bill. Thank you.
Thanks.
Randy Pearson on behalf of Augusta Health. We also oppose the bill.
Amy Parent-Seibert on behalf of the Virginia College of Emergency Physicians, and we oppose the bill.
Mr. Chairman, Keith Martin with Virginia Chamber. We also oppose the bill.
Good morning. Maddie Bussey representing the Virginia Society of Eye Physicians and Surgeons, and we also oppose this bill. Thank you.
Mr. Chair, members of the committee, Chris West with Kaiser Permanente, we oppose the legislation as well.
Good morning, Ann Harbor with Johns Hopkins University of Medicine. We have 10 cardiac services for pediatrics in Northern Virginia, and we oppose the bill.
Mr. Chairman, Mark Dix on behalf of the Virginia Trial Lawyers Association. We oppose the bill in conformity with our agreement with the Medical Society.
I don't see that very often. Okay. Yeah, close the testimony. And
the next bill is a trial lawyer bill, so get ready. Mr. Chair.
Senator Stanley, you wanted the final word?
Yes, ladies and gentlemen, I've been an attorney for 30 years. I do not do medical malpractice, but what I heard today is just we don't care about toddlers. We don't care about 10-year-olds. We don't care about the pain that, unfortunately, is inflicted by malpractice. No doctor is perfect. No lawyer is perfect. No person is perfect. And in those instances, right now, we've had an agreement since 2011 that will go on till 2035 at $50,000 increments, and little children like Artemis will not get a chance to live in what was the value of his life. This is not, what you didn't hear was a lot of, it's going to cost us a lot of money, generally, but not about what this actually is, which is trying to address a small, very small area where cases of malpractice at a patient who is 10 or under has everlasting effects. Because usually those are not small things. Usually when a malpractice happens in the toddler to 10-year range, they are significant, they are death sometimes, and they are long-lasting. Ask yourself, if you were to treat a child who suffers a catastrophic injury under the age of 10 because of the malpractice, the negligence of a doctor, that $2.6 million, if they needed long-term care, would care for them. That would be even if cost of litigation did not come out of that. What is the value of Artemis's life? Where are we not saying, yes, we understand the cap for certain things. You've seen the facts that I brought you. They did not quibble with those. Very small percentages above $1 million, $2 million, 43 cases since 2005, and even smaller amounts when we're talking about children. But they deserve our protection, and the families deserve our protection, because otherwise the taxpayer picks up the bill. We do it. It's not right. for years, and I've had the honor of sitting on this committee. It's the courts of justice. Today, justice should be served for young people like Artemis or their family. And that's why this is what it is. It's not the sky is falling, as someone urged earlier. This is not going to drive pediatricians out. What it does is bring equanimity when it comes to greedy insurance companies that are making billions of dollars off this industry. All the while, families like the McCraes suffer, or Nancy. I think what we're doing here is not going to kill the medical profession, as they claim, and it will not, certainly not, drive up costs when you're talking about a company making over $1.5 billion after payment of everything from their premiums. I urge all of my friends on this committee, let's do what's right for children when it comes to this cap. It's unworkable and it's just not fair. Thank you, Mr. Chairman.
Thank you, Senator. I think Senator Obenchain has a comment, and then Senator Carol Foy is next.
Mr. Chairman, members of the committee, I started practicing law in 1987, and one of the first two cases I worked on were the medical malpractice lawyers in here, both defense and plaintiffs' lawyers will remember these cases, were Boyd versus Bilala and Ruhr versus Hunter. In both of those cases, the constitutionality of Virginia's medical malpractice cap was at issue. And I wrote the briefs for this cases before the Virginia Supreme Court for the defendant. I worked for the insurance companies back then. And we prevailed in upholding the constitutionality of the cap. I am not hostile to the insurance companies, or at least I historically have not been, certainly not to the doctors. But I want to tell you one thing, particularly the doctors in this room. This is not something that has been brought about because of doctors. Doctors in Virginia do, I think, an outstanding job. Their heart is in the right place, and these cases happen. Tragically, they happen. And for me, if I kill somebody because of my negligence, I pay an insurance company, and I want them to make that person whole. I want them to fulfill that responsibility. That is what I'm paying them for. The system in medical malpractice is broken. It is broken not because of the doctors. It is broken because of the insurance companies. In the NFL, we see NFL football teams going for two all the time these days. In college basketball, we see them shooting three-point shots all the time. You know why? It's because of analytics. They are money ahead, points ahead, more likely to win the game because of the analytics. The insurance companies have done the same thing. They know that their insured are protected to the maximum extent of the law, and there is no consequence to rolling the dice. Their analytics show we're going to defend these cases every time. I've never, and maybe one of these plaintiffs here had an offer before suit was filed. If they did, that is extraordinary in Virginia. Even in the most egregious cases of medical malpractice with egregious damages, there is never any negotiation. There's never any offer to try and resolve the case early, maybe right before trial. But the insurance companies have broken this system. I don't know whether this bill is going to pass this year, but I would respectfully submit to the medical community, the hospitals, and the doctors that unless you insist that your insurance companies use good faith to try and handle these cases, the system is going to totally break, and this cap is going to be gone, notwithstanding any of the agreements that were made. The trial lawyers exhibited great good faith in standing up here and saying, we oppose this bill because of it's a commitment that they made. The insurance companies have not demonstrated the same good faith. And, I'm going to vote for this bill, not because I'm hostile to the doctors, but because I think that something has got to give. And, so I hope that this bill will pass.
Thank you, Senator. Senator Carol Foy.
Thank you, Mr. Chairman. Speaking to the bill.
Go ahead.
First, I want to thank the patron for bringing forth this bill and explain my vote. Caps prevent victims of malpractice from being fully compensated for damages they received as a result of negligence. It really comes down to a cost-benefit analysis. It's the cost for the insurance company profits at the expense of human costs. That's what this boils down to. And I believe that child victims deserve fair and adequate compensation. And the way that we protect and bring down malpractice insurance premiums is through insurance reform, not at the expense of preventing families of dead and disabled children from being fairly and adequately compensated. So if at the end of the day it boils down to people over profits, I'm going to side with the people every single time. Thank you.
Thank you, Senator. Anybody else have any comments? Senator Boysko.
Thank you, Mr. Chair. Speaking to the bill.
Go ahead.
Last year we had this conversation. There was a pledge that there was going to be a work group to sit together, bring the parties together to discuss how we could address those most difficult, debilitating situations where an individual has been harmed through accidental way, for an accidental procedure. But like Nancy that we've talked about. I know this bill is focused on children, but my issue is what do those families do who are devastated and will not be able to care for their loved one because they don't have the funds and they don't have the means to take care of them. This is a personal issue for me, and I've had conversations with many of the folks in this room about it. When my parents pass on, I have a family member. I don't know how he's going to care for himself. And unless we have a strong and full commitment from all of the parties to sit down and work through this, I'm going to have a hard time staying, without passing this bill. I need a firm commitment that we're going to do what they said they were going to do last year and sit down at the table together.
Thank you, Senator. Anybody else? One thing I'll just say is that I think Virginia's global cap, overall cap on damages is, I think there's only one other state in America that has a cap. I think it's Nebraska.
That's correct.
Other states that have caps don't have caps that are as nuclear as this one. And this is like a very unique, odd policy. It's one I've never supported. And when the deal that was made, I think it was in 2011, I wasn't party to the deal. It was a deal between the stakeholders, not the legislature. And I'll just note that I suspect there's only probably about, of the 140 people that were there that year, there's probably only about 30 that are left in this legislature, and it's not binding on the legislature. So having said that, I would entertain a motion.
Second.
It's been moved and seconded, moved by Carol Foy and seconded by Stanley. We report and read for the bill to finance. Clerk will open the roll.
Ayes 8, noes 4, abstentions 3.
That's an interesting one. Okay, Senator Stanley, you're into finance.
Thank you, Mr. Chairman.
Let's see. Open chain, your Craigsville one's easy, right?
Well, I have another bill, Mr. Chair, real quick.
We're going to do finance ones first, though.
Oh, all right.
Mr. Chairman.
Yeah. It's 691, I think.
Mr. Chairman, 691, if I can do it from here. The Department of Corrections has announced the closure of the Augusta Correctional Center in Craigsville. The town of Craigsville has, I forget, about 600 residents. and they built a new water and sewer plant, not because their residents needed it, but because the prison needed it. They are on the hook for about $1.5 million for the bond that was floated to pay for this water and sewer plant. The prison property is up in the air with respect to what its disposition is going to be, what this bill does, but the prison property actually contains the water and sewer plant. So if it is sold, it creates a huge problem for the town of Craigsville. This affects a transfer of the property upon which the water and sewer plant are located to the town. There is actually a reversionary interest in the original deed. This would accelerate that, simply make sure that there's no period in which the disposition of this important town infrastructure is up in the air. There is an amendment to make sure that both the water and the sewer plant and access thereto are covered. I would move the amendment.
Second.
It's been moved and seconded. We adopt the amendment. Should be in everybody's package. All those in favor say aye.
Aye.
Anybody opposed? No. The amendment's adopted.
With that, I would move the bill report.
Okay, Senator Deeds has a question for you, I think.
I've just, Senator Obenchain, as you pointed out, the town has about $1.5 million left to retire the debt. Have you got a budget amendment, or have you considered amending the bill to require the state to?
Mr. Chairman, a couple of things. While I'm not real happy about the closure of the prison and its impact on the locality, the administration did include in its submitted budget funds to handle the debt service on the prison, or excuse me, on the water and sewer plant, and to cover the operating expense. So that is in the underlying budget. I am in discussions with finance staff about whether it makes more sense to simply retire the debt rather than assume it on an ongoing basis. So I don't know that it should be covered in this bill, but I appreciate your concerns about that. I share them.
Okay. Any other questions for Senator Obenchain?
I'll second.
Okay. Is there anybody opposed to the bill?
If there's anyone online that would like to speak in opposition, raise your hand.
Doesn't look like it. Okay, so Senator Obenchain moves, Senator Deeds seconds. The bill be reported and referred to Finance. Clerk will open the roll.
My apologies, sir.
Stanley. There's Stanley. We'll get him later.
Ayes 14, no zero.
Bill reports, refers to Finance. So that leaves us with 1, 2, 3, 4, 5 bills. You want to do your judge bill or do Perry's? Let's do Perry's gun bill for dating relationships.
Are you going to do judge bill next?
Yes. Why don't we do it next?
Thank you.
And Senator, I think you have a sub, right? I do. Okay, Senator Deeds moves, Senator Boyce goes seconds. The substitute motion to adopt the substitute. All those in favor say aye. Aye. Anybody opposed? Nobody's opposed. Substitute is before us in your packet. 642. Go ahead when you're ready.
Good morning, Mr. Chairman, members of the committee. This is Senate Bill 642. This is a bill that is geared towards closing the long, infamous dating violence loophole that has been in existence for as long as I have been an attorney, has been routinely talked about and attempts to address. This bill attempts to do that. I worked with the Office of the Executive Secretary and a number of other partners to try to figure out the best way to do this. We've had, multiple versions now. But I think this is one of the better versions, and it really does two things. The first thing it does is it includes, as long as I was a prosecutor down in the Juvenile and Domestic Relations Court, one of the things that I talked to my JDR judges about, and that was commonly talked about on the domestic response team and other groups was the fact that the way that family member is defined in the code right now in 161228, it includes cohabiting partners. So those are people who essentially have lived together in the previous 12 months and had some sort of a sexual relationship, but excludes those types of people who are in a dating relationship, do not live together, even if they have been together for many years, who are in an otherwise intimate relationship but not living together and not having sex. This attempts to close that loophole through making sure that those folks are also considered in JDR, because many of those relationships are intimate in nature, despite not being sexual. And so it attempts to move those cases down to JDR. The benefit there is that Juvenile Domestic Relations Court often has particular probation officers assigned to it who deal with acts of violence that come out of dating relationships. Those can be written threats that are made, stalking type cases, or of course assault and batteries. The other thing that this case does, and it provides for things like a 24-month deferred finding in DV cases, because it adds the definition to 18257.3, which is the deferred finding code section. It also, the deferred finding statutes as they stand now, the Commonwealth Attorney's Office has to concur in a deferred finding being granted. In the 18257.3 code section, the judge can do it on their own to try to make sure that that person gets into treatment and gets the treatment that they need, because often people who are in these types of relationships will continue with the relationship despite whatever the criminal action is, as I know many of the members of this committee are well aware. The other thing that this bill does is this bill does what we see in with domestic violence relationships, people who have been convicted of those a domestic assault and battery, and it removes their firearms for some period of time. We know that statistics show us that once a firearm has been introduced into a domestic-like relationship, the chances of that person being the victim of a homicide go quite frankly through the roof. In Virginia, the Office of the Chief Medical Examiner reported that intimate partner homicide represented 32% of all homicides here in Virginia, and that 83% of those homicides occurred in the home. I will say Virginia is one of, I think, 9 states that has managed to not close the boyfriend loophole yet. We are in the serious minority on that particular part. And going back to the statistics, the Office of the Chief Medical Examiner in 2018 reported that most victims of intimate partner homicide were women, 74.5%, and they were killed using a firearm. That's 65.5% of the cases. I'm happy to answer any questions from members of the committee.
Are there any questions for Senator Perry? Senator? No? Senator Stewart.
Senator Perry, would this definition be included under the Project Exile statute? I know if it's a typical family member, but does it include somebody that is an intimate partner or dating? Do you know?
I'm sorry, the Project Exile statute, I'm not familiar. Senator Stewart. Sorry, Mr. Chairman, Senator Stewart.
There's a federal statute, Mr. Chairman, that you're aware of, and maybe Mr. Benjamin knows, that prohibits you from possessing after you've been convicted of assault of a family member, domestic violence. Does that statute include this language as well? I just am curious.
Mr. Benjamin.
Mr. Chairman, Senator Stewart, the federal statute contains similar language. And so if a person is convicted of a misdemeanor crime involving domestic violence, that's the federal definition, that would be family members, and in addition, people who are in, under federal law, dating relationships. So under federal law, if you've been convicted of an offense against someone with whom you're in a dating relationship, that's considered a disqualifying misdemeanor crime of domestic violence. And so under federal law, you're not permitted to possess a firearm. Now the catch is, Virginia has no misdemeanor offense of assault against somebody in a dating relationship. And so somebody might be convicted of assault against a person whom they may be in a, quote, dating relationship with, but federal law would not pick that up because it's not categorized as an assault against a family member. Nor does this bill create such an offense.
Senator Stewart, to answer your question.
I think so, thank you.
Senator McDougal.
Mr. Chairman.
Wait, looks like Senator Perry wants to clarify something.
I'm sorry, just one thing, Senator Stewart, Mr. Chairman, Senator Stewart. I will say we looked at a bunch of different definitions, a variety of states outside of the federal government. I apologize, I'm just not familiar with the phrase exile. But we wanted to do two things, right? We wanted to give clarity to law enforcement officers on the street, right, about where this case was going, whether or not, which code section they should be charging under, right? And so we tried to simplify our definition in that way and track several other states as well. And so that was part of our rationale for how we decided on that.
Hey, Senator McDougal, you have a question?
Mr. Benjamin, make sure we're all on the same page with protective orders, because this doesn't deal with a charge of assault or battery. This is only protective order. Is that correct?
Mr. Chair.
Ms. May.
Senator McDougal, if I understand your question correctly, it's adding it to the definition of family or household member. So that would have implications for the assault and battery of family household member or the protective orders for family abuse. So it would get picked up by both of those. Anywhere we use that definition of family or household member as defined in 16.1 would now pick up this category of intimate partner.
So, Ms. May, I think what you're saying is that this adds a new category of people to family or household member for all purposes in the code. So it would bring them into 18.257.2, and then it would make family abuse protective orders available, even though they're already available but under a different code section.
Mr. Chairman, that's a good and, to me at least, an interesting point, because back in the early 2000s, and I was here in the early 2000s, there was a concerted attempt to protect people in dating relationships. And bills were introduced attempting to define dating relationship so that folks in a dating relationship who needed them could obtain protective orders. The difficulty back then, as with today, is in satisfactorily defining with clarity and the lack of ambiguity what constitutes a dating relationship or a romantic relationship or a sexual relationship. And so in 2003, what this committee and ultimately the General Assembly did was provide that any person, not just people in a dating relationship, who had been threatened with force or violence could obtain a protective order. That's the only thing that worked, was to ensure the protection for everybody, because we simply cannot sufficiently and clearly define what constitutes a dating relationship.
I'm sorry, Mr. Chairman, if I could respond to
Senator
that.
Perry.
Yeah, I'll just say 41 states have been able to define what's significant, what's defined what a dating relationship is. We are in the significant minority of that. And while you can go get a protective order in the general district court in non-intimate partner relationships, the concern has been and remains that many of these folks are better dealt with judges down in the juvenile and domestic relations court who have very specific training on how to handle these types of relationships. It's one of the things I went round and round about on this definition. I wanted it to be clear for law enforcement who are on the scene. I wanted it to be clear for judges. But I will say, I don't think it's a reason to do this or to not do it, quite frankly. It would not be uncommon for me to be prosecuting a case, maybe not uncommon, but it does happen sometimes. I'm prosecuting a case. I think that this couple has a cohabitating relationship. My police report says that. Maybe I have some conversations with them, and guess what? I take the case to trial. Mid-trial, I realize, hey, they did live together. They did have a sexual relationship, but it was 13 months ago, so I am outside of that 12-month prohibition. Oh, wow, I'm in the wrong court. The remedy for that is the case gets out the hallway to the general district court. It is not a make or break issue, but what it does provide is that these folks can be heard in juvenile and domestic relations court, that they can get a family abuse protective order, and that their firearms can be taken from them at the state level, which we codified that whenever we took it out of in 2021 or whatever it was, whenever domestic violence people could not continue to maintain their firearms. I would say this is a long overdue fix that needs to be taken care of to protect people who are in, quote, dating relationships.
Mr. Chairman. Mr. Chairman.
Senator Stewart.
I'm sorry. I'm trying to find in the bill, as Senator Perry is talking about this, but where is romantic dating defined? I'm looking at the substitute online, I think.
It's not defined.
Mr. Chairman,
You have a
Senator Stewart.
package in front of you with the
I
substitute.
looked at that too. Is romantic defined?
No.
Oh, shoot. Is romantic defined?
No.
Okay. Thank you.
So, Mr. Chairman, if I
Yeah, Mr.
could offer,
Benjamin.
I can offer a potential solution that would sweep more broadly. But first, Mr. Chairman, I should note that what the bill does is add to the definition of family or household member intimate partner. When we define family or household member, then there is some legal relationship or financial relationship or cohabiting relationship or emotional relationship. But intimate partner is described only as somebody with whom in the previous 12 months one has had a romantic relationship without defining what is a romantic relationship, or a dating relationship without defining what is a dating relationship, how many dates would constitute a dating relationship, what type of dates would constitute a dating relationship, or sexual relationship. And so the effect of the bill is to add a category, intimate partner, to a category that requires legal or financial or cohabitation or child in common obligations, so that a relationship could be included that has none of those. It would include, for example, what we refer to as friends with benefits. It would include relationships based merely on convenience, that aren't exclusive, that are superficial, with zero emotional commitment, no consistency, undefined relationships where both people are saying, what are we? Or relationships, sexual relationships, that are merely ones of convenience. That is, they occur maybe once a year when both parties are freshly out of relationships and available to meet up for a night. The point is that what this does is include in our very definite definitions of family members a category that is not defined and cannot be defined. We learned that back in 2003. Now, a potential solution, because I think the point is well made, that with many relationship-type offenses, JDR court may have resources that are otherwise unavailable. And so if that were the goal, it could be met by expanding the jurisdiction of juvenile and domestic relations court to provide that on motion of either party, the Commonwealth or the accused, any offense in which a person in a relationship, any relationship, is charged with an offense in which another person in that relationship is the victim, then the juvenile domestic relations court has jurisdiction. That would be the same alternative approach that this committee and the General Assembly adopted back in 2003. If the need is there for JDR jurisdiction over relationship problems, then that need would exist for everyone and not just those in some undefined intimate partner relationship.
Mr. Chair.
Okay. Senator Peake, Senator Perry, you want to go to Senator Peake in first, unless you want to respond to that, Senator Perry, or?
To council's comment?
Yeah.
I'll say 2003 was now more than 20 years ago. In 2003, I just graduated from high school.
Yeah.
Mr. Chairman, Senator, thank
say,
you. I admit I'm old. I'm the dinosaur here. But it was the same problem, Mr. Chairman, back then. We could not define dating relationship, and everyone tried very, very hard because of the problems that Senator Perry speaks of.
I will say 41 states have managed to define it. 41 states. We are one of the 9 who are, quite frankly, allegedly unable in the past 20 years to find a definition. As I mentioned previously, the definition that I laid out there is the same definition that Washington, D.C. uses, the same definition that Alaska uses, the same definition that Montana uses, the same definition that California uses, and they're all able to work through it. I think we can too. Yes, I'm sorry.
Mr. Chair, yeah, this is not so much about the definition. I'll clarify a couple of things. So, Mr. Chair, Mr. Benjamin, Senator Perry. So the person, you can still get a protective order against the intimate partner, if they assault you, if they are convicted of an assault, it's almost guaranteed the court will enter a protective order which lasts for 2 years. Is that correct?
That's correct, Mr. Chairman.
Then, Mr. Chair, and during that 2 years of a protective order, that person may not possess, transport a firearm, or they are guilty of a misdemeanor, correct?
That's correct, Mr. Chairman.
All right, then, Mr. Benjamin or Senator Perry, Mr. Chair, this bill simply makes it, even if there is no protective order, if the person does not get a protective order and you have been convicted of an assault against somebody you dated, is it forever that you will be committing a crime if you have a firearm?
Mr. Chairman, that's correct.
Forever?
Correct.
Even if they do not get a protective order? Mr. Chair?
I'm being corrected that it's for 3 years by
Hold on.
Ms. May.
Hold on.
Mr.
First of all, Senator Peake, hold on. We're not cross-examining.
Yeah, Mr. Chair.
But wait a minute.
Yeah.
Mr. Chairman.
Wait a minute.
Ms. May.
Mr. Benjamin, isn't it true that under federal law, there's already a dating relationship prohibition? So even if you're convicted of a regular assault and battery, boyfriend, girlfriend, that meets the definition under federal law, the federal prohibition kicks in. But there's no state prohibition, but there is a federal one. Isn't that right?
That's correct, Mr. Chairman.
Mr. Chair.
Ms. Senator Peake, go ahead.
And you were answering, so is it forever if you commit an assault against a family member currently in this bill that would make it a misdemeanor? Or is it a 3-year, as you were getting ready to say? Or Senator Perry?
And Mr. Chair, Senator Peake, current law, the state law, if you're convicted of an assault and battery of a family household member, the prohibition is for 3 years. So it would be the same for this addition of intimate partner.
Okay. Any other questions before we get to testimony? Okay, because there's a lot of people, I see the red shirts, and there's people here to testify. So why don't we go to 5 and 5, unless there's more questions or amendments or anything. Okay?
If there's anyone online that would like to speak in favor, please raise your hand.
Mr. Chairman, Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County. I am here speaking in my personal capacity in support of this bill for many of the reasons that Senator Perry has laid out. But I will just add that General District Court is equipped to handle those crimes that happen when two individuals come together for a moment and a criminal act takes place. JDR is equipped to address those crimes where there's an either past or ongoing relationship, and that relationship is a component to bringing them together and therefore should be considered with how to handle that case. This bill addresses the long-standing problem with the fact that you could be dating an individual, get engaged, but because you chose not to move in with one another, you're treated the same as two guys that get into a fight at a bar. That is inappropriate. In addition, there are a number of jurisdictions that because of staffing issues, the General District Court assault and battery crimes aren't handled by a prosecutor. JDR court, a prosecutor is almost uniformly assigned to handle domestic assaults in that court. This would allow for very, very important cases that involve dating abuse to be addressed much more appropriately than to be swept to General District Court where they could be ignored. Thank you.
Good morning, Mr. Chairman, members of the committee. My name is Lori Haas. We wholeheartedly support this bill. We know several things. Number one, data and research has shown that a history of violence is a large indicator and predictor of future violence. If someone is convicted of assault and battery against a person in a dating relationship, they do, in fact, need to be prohibited from owning a firearm for a period of time. The prohibition, if a person behaves and doesn't get any more convictions during that window of time, the firearm rights are automatically restored. The second point I'd like to make is that federal courts and federal systems are not prosecuting these cases. U.S. attorneys don't typically take domestic violence cases. The senator is very accurate and wise to think about how these cases are handled. They need to be in JDR court, and they need to be developed and the information presented to a judge. We have judges. Judges. That's why we have them. They can judge the facts of the circumstances. They can judge the relationship. They can determine if the relevant information brought to the case does identify a dating relationship. As the senator said, the definition has been added at the federal level, and 41 states do this. I hope it'll be the pleasure of this body to pass this bill. Thank you.
Okay, thank you. Next, if there's less than 2 minutes.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. For all the reasons given, we support the bill.
Okay, thank you, sir. Next.
Mr. Chairman, Peggy Pridemore from Fairfax County. I'm a volunteer with Moms Demand Action. On average, 70 women are shot and killed by intimate partners every month. And nearly 1 million women overall have reported being shot or shot at by intimate partners. Thus, Moms Demand Action urges you to pass this bill. Thank you.
Thank you, ma'am. Next.
Keith Conway, gun safety advocate. That 70 every month works out to about 840 every year. I support this bill.
Thank you. Next.
Mr. Chairman, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We very much appreciate being able to work with Senator Perry on this bill. We do support it, and we are working actively outside of session to address some of those gaps in Virginia code with regards to defining intimate partner violence. And this points us in that direction of being able to do that a bit more clearly. Thank you.
Mr. Chair, there's one person online that would like to speak. Okay. Virginia, please unmute.
Unmute and turn your camera on, please.
Virginia, please unmute.
Okay, are there those who will are in opposition?
I think I got it. I support the bill. Member of the Charlottesville Center for Peace and Justice and the Charlottesville Coalition for Gun Violence Prevention. Thank you.
Okay, thank you, ma'am. Are there those in opposition?
If there's anyone online that would like to speak in opposition, please raise your hand.
Okay, Senator Perry, you want to wrap up?
Yes, members of the committee, I would ask that more than 20 years on, we decide that we can define dating relationship like other states and the federal government have been willing to do, and not only protect victims of domestic violence, protect them in the appropriate courtroom where they can get the services that they need, where offenders can get the services that they need. It benefits both parties. And that we remove those firearms for a period of 3 years upon conviction so that those people can be safe, they can work out what they need to, give them that ability without split-second decisions that can't be reversed. Thank you all.
Okay, got a motion to report and re-refer. Is there a second? Second. Okay, are there other motions? If not, open the roll. Okay, ayes 9.
Ayes 9, no 6.
Thank you. Okay, I'm going to turn the chair over to Senator Boysko.
I can do it.
I'll turn it over to Senator Boysko, and we're going to do my bill with Senator Obenshain 710. 710 is simply a bill that reflects the Judicial Council's.
Mr. Deeds, is there a substitute?
I don't think so. I don't think there's a substitute.
I've got an amendment.
It looks like there is.
Okay. Well, so we've already adopted that substitute? Okay. Well, Senator Obenshain and I have some issues to resolve, but that's certainly something we can still talk about in finance if you want to.
Senator Obenshain, did you have a question?
Well, no, I'd just like to speak to it and offer an amendment. I mean, you know, we talked about this 2 weeks ago when this was up, and you know, we adopted a process shortly after we went through, I guess about 10, 12 years ago, we had a real imbalance of judges in Virginia, and the offered solution was to redistrict. all of the circuits around the state. And it created an enormous uproar because we had some folks who were very adept at getting new judges for their circuits. And so what we did was we decided we're going to let the numbers decide, and we're going to let the Judicial Council, with the help of the National Center for State Courts, decide what circuits need new judges and which ones don't. And what happened this past year was that the Judicial Council, through the National Center process, recommended adding circuit court judges, a circuit court judge in 4 circuits, including the 25th Circuit. And Senator Deeds used to represent a part of the 25th Circuit. I now represent the 25th Circuit. And this resolution, though, does not include the 25th Circuit's recommended judgeship. And I will tell you that I went and looked at the numbers for Roanoke County, which is pretty comparable, has been pretty comparable. Roanoke County has 2 judges for that one county, 2 circuit court judges. In 2023, Roanoke County had 5,335 new circuit court filings. In the same year, Augusta County had 5,492, about 500, 600 more than, about 100 more than Roanoke County. Augusta has 1 judge, not 2. They are handling the same number of filings right now with 1 judge compared to the 2 in Roanoke County. Dispositions, Roanoke County had 5,030 dispositions with 2 judges. Augusta, 5,837 dispositions with 1 judge. I spoke with the circuit court judge in Augusta County, who now is sitting pretty much exclusively there, and he's working 65 hours a week trying to keep up with this caseload. And, I would hope we would adhere to this process and let the Judicial Council make these recommendations rather than have us arm wrestle over new judges for our circuit. I'm not going to assert that other circuits don't need a judge, but this one really does. And I made phone calls to try to confirm that. So, at appropriate time, I would suggest an amendment to line 82 to change 6 to 7 for the 25th Judicial Circuit. I would hope that to have some support for that.
Madam Chair,
Senator Deeds.
if I can address why I left the 25th out, I've practiced law for 40 years, and nearly all of that has been the 25th Circuit. When I started practicing law, there were 3 judges in the circuit, 25th Circuit, and then there were 4. There were 4 for most of the 40 years. They added a 5th one about 10 years ago and a 6th one 2 years ago. The judge from Augusta County, I spoke to him too. He was my candidate, and I'm sure he's going to do a good job. He's been there seven months. The way it works right now, he sits in Augusta all the time. The judge that sits in Stanton sits in Augusta 4 days a week. The judge that sits in Waynesboro sits there 4 days a month, rather. The judge that sits in Waynesboro sits in Augusta 4 days a month. The 25th Circuit is one of those big circuits, rural circuit. That's just 3 of the judges. They sit in 3 courts, Waynesboro, Stanton, and Augusta County. The 3 other judges sit in courts in Buena Vista, Lexington, Fincastle, Newcastle, Warm Springs, Covington, and Monterey. They handle the more rural parts of the jurisdiction. Looking at these numbers, the 25th has kept, only has, I guess, 4 general district court judges and 5 juvenile court judges. I just don't know that overall the work is there for there to be a seventh juvenile court or a Seventh Circuit Court judge. I've practiced there a long time, and I don't see the workload. I've spoken to the Circuit Court judge, and I know that he's working hard, but he's only been there 7 months.
Okay, any questions for Senator Deeds? Senator Peake?
Mr. Chair?
Peake?
Yes. Question just for Senator Deeds. I mean, I know we all have our personal observations, but isn't this why we turned it over to that commission, so they look at the numbers and it's objective instead of...
Mr. Chair, Senator Peake, I would suggest that since the pandemic, nearly every request has been granted. And I would suggest that if you look at the numbers, there have been few granted that have had less demand than this one.
Mr. Chairman.
Senator Peake, I would just say I've participated in this process only once. I just got on the district court committee. The chairman appointed me to that last year, but my impression is that the court tends to sort of follow the recommendations of the members who are in the room. When that happens, I think Senator Deeds was not at the meeting for Circuit Court because he had to be in another meeting. But Senator Stewart, go ahead.
Thank you, Mr. Chairman. I actually served on that committee for quite a while. I'm not sure I got the same impression. They typically did the workload study,
right,
and they determined who needed the judges,
right,
and they made a recommendation. In this case, I think they made a recommendation, and it was left out. And so I would second Senator Obenshain's amendment that he just made and try to get the judge in for that district as well, and then let's move the bill forward. I'm not sure why there's reluctance to add a judge in a district when the Judicial Council has said we need one there.
So I walked in. Did I walk in the middle of a motion?
Yes.
Okay.
Got a judge who'd like to testify.
Okay. Yeah, and Senator Obenshain points out that he has a judge who's online from the circuit, I think, who wants to testify about situations. So, do we?
I don't think you need it.
Hold on 1 second.
Not here.
Okay, so what I'm going to do is I'm going to take the judge's testimony. I don't think there's anybody else for or against the bill, and then we'll take the amendment, and then we'll see where the
If
bill
there's
goes.
anyone online that would like to speak for this bill, please raise your hand.
Is it Judge Goodwin? Is that what you said?
Good one.
Goodwin?
Yeah.
Call him up.
William Goodwin, you may unmute. Please make sure your camera's on.
Doesn't look like he's responding. Want to go by temporarily? Or?
Sure.
Okay, why don't we take this by temporarily so we can get this, maybe this judge he's on the bench. Yeah, let's go to Senator Bagby's bill. So Senator Bill 547, Bagby.
Thank you, Mr. Chair. Mr. Chair,
Do you have a substitute or anything?
there's several amendments, so I'll ask someone to move the amendments.
So moved. Second.
Okay, let's see. Yeah, the amendments have been distributed and moved and seconded. We adopt the amendments. Somebody want to explain real quick? There's a lot of them. Taylor, you want to do it?
Yeah.
Sure, Mr. Chair. The amendments specify that the training is related to law enforcement officers communicating with individuals with an intellectual disability or a developmental disability as defined in 37.2, such as autism spectrum disorder. The introduced bill just referenced communicating with individuals with autism spectrum disorder, and it also adds one representative from DBHDS to the list of people that DCJS is to consult with in developing this training, and then it also changes the dates in the enactment clauses so that DCJS will have to have the training established by January 1st, 2027, and that anyone employed as a law enforcement officer prior to the date when this bill is to go into effect will complete the training by July 1st, 2028.
Thank you, Taylor. It's been moved and seconded to adopt the amendments. Any further discussion? All those in favor, say aye. Aye. Anybody opposed? No. Okay, the amendments before us. Senator Bagby, explain to us what your bill does as it's been amended.
Thank you, Mr. Chair. Mr. Chair, the amendments offered that you just heard about our product of outreach with DCJS, DB, HDS, and the ARC of Virginia. The bill requires the Department of Criminal Justice Services to establish compulsory minimum and in-service training standards for law enforcement officers on communicating with individuals with intellectual disabilities or developmental disabilities such as autism spectrum disorder. The bill requires that such training standards be established in consultation with at least one individual with autism, one family member of individual with autism, one specialist who works with individuals with autism, one representative from the Department of DBHDS, and one representative from a state or local law enforcement agency. And that is the bill, Mr. Chair.
Can you revoke my proxy? Thank you, Senator Bagby. Any questions for Senator Bagby? This bill, I guess, requires DCJS to train law enforcement officers about autism spectrum disorders, basically what it does. There we go. Okay. Is there anybody opposed to the bill?
Second.
Okay, Senator Stewart moves, and somebody over here, I think Boyce goes second, that we report the bill and refer it to finance. Any further discussion? The clerk will open the roll.
Thank you, Sarah.
Ayes 15, no 0.
Mr. Chair?
Yes, sir.
I'm sorry, hold on one moment. This is where I just don't want to get in trouble.
You might turn your microphone on, Senator Bagby.
I think that bill is supposed to go to finance.
Yeah, it did.
Oh, perfect. I just didn't want to get in trouble.
Nope. You were still on Senator Lucas's Christmas list. Okay. I think, let's go back to Senator Obenshain's bill. I think we now have Mr. Judge Goodwin back online.
Senator Deeds' bill.
Yeah, Senator Deeds' bill, yep. I'm sorry. My bad. Has he got his Zoom working yet?
William Goodwin, please unmute and make sure your camera's on.
We can hear you.
When I tested, the camera was on and the video was working. I mean, the audio was working.
I don't know, Your Honor. I think we can make you an exception.
I'm sorry.
Go ahead, sir.
All right. I am Judge William Goodwin. I'm retired as of last July. I was the former circuit court judge of Augusta County in the 25th, and I was the chief judge of the whole 25th Circuit. I sat in Augusta, and I concur with the current judge that it's an incredibly heavy docket there. We have 53% of the total docket for the entire circuit within the eastern part, which is Stanton, Augusta, and Waynesboro. There are 10 total venues with 6 judges, 3 in the western part of the state, 3 in the eastern part, and the Stanton, Waynesboro, Augusta County courts cover about 53.7% of all the cases. I too was working 65 plus hours a week, and we could not keep up. If you look at the cases, we had about 443,000 minutes, judge minutes, which was up 10% from 22. We handle 17,710 cases, and these numbers come from the executive summary that was provided to the council. That was up about 0.6 for this year versus the previous year. we have our particular court has a judicial caseload study of about 1.64 judges for our individual court, and our numbers from the executive summary across the board indicate that.
So, Judge, do you think that the circuit needs another judge?
Absolutely. Absolutely. Agree with the previous judge. We're at 1.08 judges based on the workload study, and that's consistent with what the other 4 courts do. Of course, the first district is higher, but the others are similar to that, depending on which window you pick for the time frame. And it was discussed, the primary issue in our jurisdiction is the distance. I sat in Allegheny County for 2.5 years, and it's about an hour and a half each way going over there to sit.
All right, Judge, thank you for your testimony. Is there any further discussion about the amendment? Senator Obenshain.
Let me close on the amendment. Mr. Chairman, you know, we've talked about the limitations of the National Center issue. And as a matter of fact, Senator Deeds and I have talked about that with respect to some of the rural courts and particularly the 25th Circuit. You know, there are mountains that make it difficult and distance that make it difficult to travel back and forth between these courts. This is not Fairfax where somebody has to walk down the hall to cover another courtroom. This is somewhere where somebody has to drive from Allegheny County to Waynesboro or Augusta County or from Botetourt up to Augusta County in order to meet some of those needs. And yes, the Waynesboro and Stanton Circuit Court judges are already helping to cover some of those needs. But you know, the difficulty here is one that is exacerbated by geography. We committed ourselves to follow this National Center process. I would hope that we'd set aside, you know, the parochial interests of me or anybody else and follow the system that we agreed to abide by. So I would hope we could vote for this amendment.
Any further discussion about the amendment? No. Okay. So the amendment is to add the 25th Circuit back into the bill. All those in favor say aye. Aye. Anybody opposed say no? No. Why don't we put it on the board? Yeah, this is for the Obenshain amendment.
Ayes 6, noes 9.
All right, the amendment's failed.
I move we report the bill and re-refer it to finance.
Second. Any further discussion? Okay, clerk will open the roll.
Ayes 14, noes 0, abstentions 1.
Bill reports refers to finance. That leaves us 2 expungement bills. My bigger bill and Senator Aird's smaller but complicated bill, I think. Okay, it's not complicated. So, Aird, you want to go first, and then we'll do mine? And those are the last 2 we have that have finance impacts.
Mr. Chair, before you is Senate Bill 482, my very simple juvenile expungement bill. And I'm joking only halfly because this was originally an expungement and sealing bill, but after the substitute that is before you, it largely becomes
Okay, so Senator Deeds moves, Senator Boyce seconds that we adopt the substitute. All those in favor say aye. Aye. Anybody opposed? No. Okay.
Thank you, Mr. Chair. So the substitute removes some of the sealing provisions within the introduced bill. As we heard from OES that these changes would have the unintended adverse effects on the implementation of the 2021 sealing legislation from basically an IT perspective. So we went ahead and removed that language. I also understand the fiscal impact of this legislation was largely as a
result of that. So while this does need to go to finance, I believe that removing this language will make it neutral. Furthermore, the substitute includes clarifying language around how records can be considered during future criminal proceedings. We heard a great deal about this, and it adds 2 additional circumstances where juvenile adjudication orders would be necessary to put into evidence, in the addition to possession of a firearm by a felon, sex offender registry, and false information on firearm consent forms. And so lastly, the additional change in the substitute is that it changes the verbiage in the code. Wherever it currently says date of last hearing, it now says date of final disposition, since that would clear up any confusion around things like restitution hearings or other long ongoing hearing circumstances. So, Mr. Chair, with those changes in the substitute, properly before you now is Senate Bill 482, and ultimately it does 3 things. First, it ensures that once a child turns 18 and at least 3 years has elapsed since the date of their final disposition in any juvenile case, that the court records cannot be considered for future criminal proceedings. It also removes the provision that makes all juvenile court records publicly accessible for kids who have been adjudicated delinquent of a felony at age 14 or older. And lastly, it shortens the current waiting period for the expungement of misdemeanors and non-conviction juvenile records from 19 years old and 5 years since the last court hearing down to 18 years old and 3 years since the final disposition. Mr. Chair, members of the committee, this is a significant problem here in Virginia around how we treat juveniles and their previous records. I believe the Commonwealth is a bit out of step with how we should be treating juvenile court records. And especially given Virginia's recent efforts to amend expungement laws for adult records. So I'd like to wrap up just by expressing that expanding our juvenile expungement laws would offer second chances for young people so we can ensure their early mistakes don't become lifelong barriers. And so I'm hoping that, again, Mr. Chair, with the substitute, the concerns that were expressed earlier to the introduced bill, that this has addressed those and we can move this forward.
Thank you, Senator. Taylor or Mr. Benjamin, did this substitute to the bill address some of the concerns that were raised in the work group discussions? Or?
Mr. Chair, I think some of the concerns in the work group were dealing with the sealing provisions, and those provisions are no longer in the bill, so I do think.
Okay, great. Okay, so why don't we...
Can I ask a question?
Yeah, Senator Obenshain.
So, and I think this question is relates to the substitute, but my understanding, I want to know if a juvenile that's 15 years old rapes an 11-year-old, and he's given an indeterminate commitment by DJJ for sex offender treatment, and he's released to parole at 17 and 6 months, and then he turns 18 and commits sexual battery of a 13-year-old. This would mean that DJJ would be unable to provide records of the original rape in either the detention hearing or the sentencing proceeding. Is that right?
I'm trying to
like council might have
track
answered for you.
all of those different variables. And so, council, can you clarify? Because I know we did add that language around the sex offender registry as an exception, but given the specific timeline that Senator Obenshain has laid out.
Council, do you have an answer to Senator's question?
Mr. Chair, I may need him to repeat the question and then follow along with I think the language that Senator Obenshain's probably looking at is lines 94 to 102. I just may need you to restate the question.
Yeah, the question is, the hypothetical is, at age 15, a juvenile rapes an 11-year-old. He's given an indeterminate commitment to DJJ for sex offender treatment. He's released to parole at 17 and 6 months with special sex offender conditions. juvenile turns 18 and commits sexual battery of a 13-year-old. DJJ would be unable to provide the records of the original rape in either a detention hearing or sentencing proceeding on parole violation for that rape, correct?
I guess, yeah, I'd be curious. I mean, I thought since it says 18 in 3 years.
Age 21 then.
15.
Senator? Okay. Taylor, you got to answer that question?
Just as far as I follow the language, I think that's correct, given the language on lines 94 to 102. I'm just trying to look through the clauses of where this bill has specifically said that those records cannot be considered, and they're listed in those clauses, and I think that would be correct.
Mr. Chairman.
Senator Perry.
I have a same question, essentially with relationship to the pretrial risk assessment and lines 94 through 102, and the idea that someone could be, as a juvenile, rape someone, be convicted of that offense as a juvenile, be sentenced to DJJ where they can stay until the age of 21, and upon their release get out and immediately rape someone else. And I believe the way that I read this bill, the judge would not be able to know or consider that prior rape in deciding whether or not they should get bond on the new rape. That's the way I read this bill.
So we got the question answered. Any further discussion? Sorry. Any further discussion before we go to testimony? Okay. Why don't we go, I don't know, gosh, 5 and 5, I guess. We've got to have time for my bill, too. So come on up, Mr. Pokenglass. Get up here, guys.
If there's anyone online that would like to speak in favor, raise your hand.
Mr. Chair, can I just read a brief statement from someone who was unable to make it today?
Sure.
Okay.
Use your minutes as you please. You
All right.
3 people behind you and people online, too, probably. So.
Thank you, Mr. Chair, members of the committee. This is on behalf of Julie McConnell, who's a law professor at the University of Richmond School of Law and director of the Children's Defense Clinic. She's served as both a public defender and a juvenile court prosecutor, and she asked that the committee support the bill. Children need the opportunity to grow and have the chance to be productive citizens. Delinquency records can be a huge impediment to their future. This legislation recognizes that our kids are more than the mistakes they make when they are young. I'm here, Rob Pokenglass, representing Justice Forward, Virginia. We support the bill. If we believe in having a separate court system for children, then this bill makes a lot of sense. It's in line with those principles because it keeps the records that children get when they are children in juvenile court. It also repeals the provision that makes juvenile court records public if the child was 14 or older when at the time of the offense. Thank you.
Yep.
Thank you, Mr. Chair and members of the committee. My name is Lauren McGarry. I'm an attorney with the Legal Aid Justice Center, and we support this bill.
Thank you, Chair and committee. I'm short. Sheba Williams with No Left Turns and member of Virginia Expungement Council. We support the bill. Thank you.
Thanks.
Tanya Mallory with the Virginia NAACP. We support the bill. We align our comments with the Director of Rise for Youth, who I believe is going to be speaking online testimony. Thank you.
Are you a support or opposition? Your opposition?
Opposition.
Okay, all right, hold on. Okay, there's nobody online, so let's reset the clock.
Valerie Slater, you may unmute and make sure
she's
your
in-
camera's on.
Somebody in support popped up, okay.
Hello, my name is Valerie Slater, and I'm with Rise for You. Can you all hear me?
Yes, we can hear you. Can you please turn your camera on?
Good morning. My name is Valerie Slater, and I'm the Executive Director of Rise for Youth, and I'm also a criminal defense attorney, and I support this bill. We support this bill.
Great, thank you, Ms. Slater. Okay, now there's nobody else, right? Okay, let's go to opposition, reset the clock.
If there's anyone online that would like to speak in opposition, please raise your hand.
Good morning, Mr. Chairman, members of the committee. My name is James Toohey on behalf of the Department of Juvenile Justice. Since youth can be on parole past the age of 18 and up to the age of 21, therefore this limiting language would render unworkable DJJ's and the court's responsibilities to manage probation and parole cases for that period, as well as for review hearings. Senator Obenshain noted a very applicable example that was accurate, that creates a problem. One other problem I'd like to mention, there are a number of problems, but one other, within the confines of the time I have here, one other problem I would like to note is with regard to serious offender commitments. So if a 15-year-old or older youth is committed to DJJ as a serious offender pursuant to 16.1, 285.1, a review hearing shall be held 2 years after commitment and every year after that to determine possible release. The court shall consider, among other factors, the nature of the offense committed and the manner in which the offense was committed. Under this bill, the statutory requirements of the serious offender review hearing could not take place at the third-year review hearing and each annual review hearing thereafter. Due to the ramifications on other provisions, this bill would I believe, need to be more than just a simple 5-page bill. It affects a lot, and it's even if persons are in agreement with the bill in theory, it is I believe far from ready to be implemented in prime time, given the statutory conflicts that exist with other provisions of the code. And that example regarding serious offenders and the example mentioned by Senator Obenshain are just two examples. If I had time, I could list another example. Thank you.
Okay, thanks.
Good morning, Mr. Chair. My name is Megan Clark. I am Commonwealth's attorney in Prince Edward County, and I stand before you all on behalf of the Virginia Association of Commonwealth's Attorneys. And respectfully, we do oppose this bill in its current form. When we are looking at and understanding the purpose of the juvenile justice system and that we do need to look at rehabilitation, we also, of the offenders, we also have to look at public safety and our victims' rights. We believe that including all of the crimes that are included would not benefit public safety and would not benefit victims' rights. Senator Obenshain brought up a very good point, using the crime of rape and using the fact that if someone has been committed for an indeterminate period, or as my colleague has talked about, for a determinate period, after the date of the final hearing or adjudication, depending on the timing of when those people are released, we will not be able to bring those records into courts. One of the main issues is letting the public know about someone who has committed a violent act, such as your rape, such as your other sexual assaults, and actually looking at stalking as well. We believe that the prior acts are important for bond determinations and for future hearings and for trying to determine what someone's disposition should be. We also believe that an unintended consequence, if this bill were to go into effect, is that we would see more juveniles being certified and transferred as adults. And if they are certified and transferred as adults, then we are circumventing the purpose of the juvenile system as well, because we are trying to create a record of this person's violent history. And in order to do that, they would have to be treated as adults. Thank you very much for your time.
Thank you. Is there anybody online who's opposed? Nobody? Okay. All right, so the bill's before us. Today, we have to get this bill moving today or else it can't move. And Senator, I think, are you willing to continue working on this to tighten it up some based on the testimony that we've heard today?
Mr. Chairman, I move to gently lay it on the table so we continue to work on this.
We don't have that motion in the Senate.
Oh. What is it?
You want to carry it over? Okay.
Yeah, move
All right.
to carry it over.
And
Okay.
Mr. Chairman, I'll just, in closing, say, again, I have heard the concerns and some of the issues raised, and I think at the end of the day, I believe we do need to find a path forward with this legislation, because ultimately, we are plaguing our young people to be burdened by mistakes that they have made in the past. And we are also treating them differently now in the Commonwealth than we do the adults who have made mistakes in the past as well. And so I've heard the concerns, and we will continue to work on this. But I'm hoping that we can find a path forward because this is critical legislation that we address.
Yeah, and Senator, I think that at least on one side of the dais up here, there's an agreement with you that we need to do something that, with regard to the lack of ability to expunge juvenile charges. But there are obviously some significant or more extreme cases that this kind of inadvertently picks up. And there's probably a sort of more scalpeled way to get at what you're trying to get at, I think.
Certainly.
Senator Foy moved, Senator Perry seconded to carry the bill over to 2025. Maybe we're probably going to have a meeting at some point in the next 12 months. We can talk about it then or something and see if maybe we can have it here back next year. Okay. Any further discussion? Clerk will open the roll. All right, Senator Deeds, you're taking over.
Okay, I'm trying
Senator.
Yeah.
Ayes 15, no zero.
Ayes 15, no zero. The bill reports, or the bill's carried over, rather. What, do we have other finance bills? Senator Survels, what's your bill number?
The last one is the last one has a finance impact. Is actually before we MJ pointed out we ought to take up my class action really quick to adopt the substitute, which removes the fiscal impact, so that we're not subject to the finance rule. So, if we could bring up Senate Bill 259 really quick, just to adopt the sub.
Senate Bill 259. There's a substitute, and it's not been distributed, I assume.
It's out.
It's in the packet.
Yep.
Okay. Do I have a motion to adopt the substitute? A motion and a second to adopt the substitute. All in favor, say aye.
Aye.
Okay. And any opposed? Okay. The substitute's been adopted, but we're not going to hear that bill.
Yeah, I'd like to take it by temporarily. We can see if we can get to it later, but not right now.
Okay.
So we need to go to 14 now. I'm sorry, not 14. 504.
Senate Bill 504. Turn your attention to Senator Survell.
Thank you, Mr. Chairman. So this bill is sort of like an expungement cleanup bill. It does several different things, which I'll walk you all through. Some of which are in response to the ceiling legislation we adopted last year and some discussions we've had at the Crime Commission, and some of which is in response to some Supreme Court cases that have come down. So, first of all, on line 25 at the top there, it makes available court-appointed counsel for people whose charges have been expunged. You all might not remember it, but when we passed the ceiling legislation in 2021, it makes court-appointed counsel available for people to have their charges sealed, but we did not make it for people who have it expunged, which doesn't make a lot of sense given the fact if you're expunged, you're innocent, but if it's sealed, you're guilty, which is why. So it seems to me if there's anybody that's entitled to court-appointed counsel for anything, it's the people who are innocent and are trying to get their record expunged as opposed to sealed. So that's the first thing it does. Oh, I'm sorry, is it a substitute? Oh, we need to adopt the substitute. Mr. Chairman, I move the substitute. Aye. Aye. Thank you. And all the substitute does is picks up some language requested by the Virginia State Police to make some of their responsibilities clear. It doesn't really change the substance of the bill. So then the next thing the bill does is reverses two Supreme Court decisions which came down in the last probably 8 months. One was the Fornes case, where the Supreme Court held that you were not entitled to expunge if your charge is amended to a lesser included offense. So, for example, if you're charged with DUI second and it's amended to DUI first, or you're convicted of DUI first, you cannot expunge the DUI second. So this first makes clear that that you can do that. That's what the lines 39 through 44 do. The second case it reverses is the Williams case. And the Williams case reversed or really messed up the Dressner case. The Dressner case was the case where the Supreme Court held that if your charge is amended to something that's not a lesser included, you can expunge the original charge. So if you're charged with DUI and you're convicted of reckless, you can expunge the DUI. And the Supreme Court really muddied it up. I'm not even going to try and explain what their standard was they adopted, but it's caused a lot of confusion in the legal community about what it means. And what this makes clear is what otherwise dismissed means and the lesser included stuff. So between line 37 and 44, it clears that up and makes it clear that if you're convicted of something different than what you're charged with, you can get the original charge expunged. So that's basically what those lines do. Then you go down to line 58. This deals with another problem that's been out there. There's been some confusion in the community about whether or not you can expunge protective orders. And so what this says is that if an emergency protective order is issued, that's included within an expungement if it's connected to a criminal charge. So if the criminal charge is expunged and there's an EPO, they both go. So you don't have the criminal charge expunged and then the EPO just standing alone out there for the public. In addition, it says that a court can expunge a preliminary protective order if the facts that underlie the protective order are tied to a criminal charge that got expunged. It doesn't apply to all protective orders, just protective orders that are tied to a criminal charge. So the Commonwealth Attorney should have a file in their office about those facts. They shouldn't have to do some investigation. They should have a file in the charge, and that's what that does. Then, if you go down to the next page, lines 79 through 82, the Court of Appeals came down with a case this year. This basically confirms a Court of Appeals case. There was a circuit court, I don't remember where it was, western part of the state, I think, where the judge found that a person was not entitled to an expungement because he could not definitively show that the dismissed conviction had caused him to lose his job or employment or credit. And the Court of Appeals said that's wrong. You don't have to show that your life has been all screwed up by the fact that this dismissed charge is out there. The Court of Appeals said, all you have to show that it's possible your life could get screwed up by the charge being out there. And I thought that ought to be in the law specifically, so we don't have to worry about either the Supreme Court reversing that or another panel on the Court of Appeals getting it wrong. So that's what that amendment does. And then let's see, lines 120 through 131 make it clear this is the court-appointed counsel for expunged charges. It just basically adopts the exact same regime we have for sealing for expungement. And then let's see, lines 141 to 143 make it clear that a person who's seeking an expungement or an expungement can do so with using a pseudonym. The reason that's important is because if a person gets an expungement or they get their charge sealed and they appeal it to the Court of Appeals of the Supreme Court, their name goes all over the opinion, which totally defeats the purpose of obtaining an expungement, is to have your name on a Court of Appeals case or a Supreme Court case. So this allows you to use a pseudonym to do the appeal so that your name's not out there. And then I think that covers about all the different things it does. Oh, sorry, the last thing. Two last things. Lines 365 to 66 make clear that legal aid can apply for reimbursement as court-appointed counsel. Just makes clear that they can do that. And then the last thing it does on lines 378 through the end, when we adopted the sealing legislation in 2021, we allowed third-party corporations to access lists of sealed charges so that they can clean their records up. Right now, those of you who practice might understand that, like, sometimes you get an expungement on somebody, it disappears from the court record, but these private background check companies still have it in their database, and so the expungement's worthless. For the sealing bill, we said they can access these lists to clean up their files, but we did not make the lists of expunged charges available to these companies. And so this basically says these companies can access lists of expunged charges. In exchange for that, they subject themselves to civil liability if they continue to publish it. And so this just aligns the expungements with the sealings. That's an error we didn't make when we passed the original law. So that's basically what the bill does. I think it's a lot of cleanup kind of stuff. And I'm happy to answer any questions.
Do any members have questions for Senator Servell? Okay, we'll hear from people on the bill. Are there people that are in favor of the... Senator Obenshain's got a question.
Yeah. Lines 92 through 94. You may recall that we, I think, reported out Senator Stewart's bill that required the consent or agreement of the prosecutor to expunge those prior charges. Is there a reason you think we ought not do that? I mean, somebody who, I can think of situations where it's could be highly relevant.
Sorry, you're asking me whether or not we ought to require the consent of the Commonwealth Attorney to an expungement?
Yes.
No, I don't think that. I mean, I've known some Commonwealths that don't agree to basically any expungements, and so you often have to fight out many of them.
Mr. Chairman, I just point out this is inconsistent with the bill that we've already, I think, passed.
Except well, that one had to do with cases that are deferred for dismissal as part of a plea agreement. This, Mr. Chairman, this bill has to do with a broader universe of cases than that specific policy.
So you disagree that it's inconsistent?
I don't think it's inconsistent. I think it's. I mean, if a Commonwealth Attorney comes in and says they agree with an expungement, most judges will sign it. This allows you to obtain an expungement even if a Commonwealth says, "I don't want it. I don't agree."
Mr. Chairman.
Yeah.
Senator Stewart.
It's really a different bill. So mine just dealt with cases that are taken under advisement, and everybody's in agreement with that. There was an inconsistency that essentially said, it had to be on the order in advance, and we removed that, and we included a similar provision in there to allow us to have a charge expunged if the charge was reduced from a higher charge as part of a plea agreement. So his is a much broader bill than mine was. Mine is.
Yeah.
Okay. Now I think we're ready to take testimony.
Okay.
If there's anyone online that would like to speak in favor, raise your hand.
Rob Bogenpass, Justice Ford, Virginia. We strongly support the bill. This corrects, as the senator said, some Supreme Court cases where there was a concurrence from Justice Mann who basically pleaded with this body to do something because the standard is so difficult for the appellate courts on what it is that constitutes an otherwise dismissed case. So the senator's bill clarifies all that in a meaningful way. Again, these are non-conviction records. These are cases that were null pros or dismissed or where a person was found not guilty. And as the senator said, in large parts of the Commonwealth, when you practice in this area, as I have, there are Commonwealth's attorneys who just object. If the person has any other convictions on their record, they will object to expunging the non-conviction records. So we support the bill. Thank you.
Okay, thank you. Next.
Thank you, Mr. Chair and Committee. My name is Lauren McGarry. I'm an attorney at the Legal Aid Justice Center, and we support this bill. This bill would clarify the current statute in a way that would help people impacted by the statute get the relief that they seek so that they may move forward with their lives. This bill also provides more specific guidance to both the courts and transparency to the petitioners about the circumstances that may qualify for relief. For these reasons, we ask that you support this bill. Thank you for your consideration.
Thank you very much. Is there
Mr.
anybody
Chair,
else?
there's one person online that would like to speak. Valerie Slater, please unmute and make sure your camera's on.
Ms. Slater? Are you there? Please turn your camera on.
Good morning. My name is Valerie Slater. I am Executive Director of Rise for Youth and a criminal defense attorney. And for all of the reasons you have previously heard, we support this bill.
Okay, thank you, ma'am. Is there anybody else?
Looks like she's in court.
Is there anybody that has another view? Anybody that's opposed to the bill?
If there's anyone online that would like to speak in opposition, raise your hand.
Morning, Mr. Chairman, members of the committee. Carlos Hopkins with Gentry Law on behalf of the Circuit Court Clerks Association. And I thank the patron for allowing us to speak to our concerns. We don't take a position as to the policy behind the bill. The clerks have some concerns as to the implementation and the workload that it would place on the offices of the clerks. And so without spending too much more time on the details of that, it would require a lot of manual efforts in order to actually remove the original charges to get that matter expunged and then upload into the appropriate systems. And so because of that amount of manual involvement in the workload, we have concerns that we bring to the committee. Finally, we would just request that the remaining expungement and sealing legislation goes into effect in 2025. We'd respectfully request that this matter be carried to 2025 as well.
Okay, thank you. I think the workload issues are probably why it's going to finance.
Yeah, and the clerks have also requested a workload study as a budget amendment, which I'm carrying.
And unless there are alternative motions, please open the roll.
You can fix it up there.
Can I strike the? Just strike the roll.
Ayes 13, noes 1.
Just vote me no.
Okay. Thank you.
Ayes 12, noes 2.
I think Senator Jordan has a bill now. She has some people here for, I think, so, that we heard before. We can do that next. Okay.
Senator Jordan is it's 637. Is that right?
Would you like me to start with Senate Bill 637? I do, and I can be brief. We do have an amendment to Senate Bill 637, which should already be in the packet, correct?
Okay. Is it an amendment or a sub?
It was a striking on line 46 and 45 through 47, so I believe it would be an amendment, but counsel?
Sabrina, we got an amendment or a sub?
Mr. Chair, I don't believe that we received that amendment.
We did submit that. I can give you what that would do here. You need a copy of it. I'm going to go ahead and proceed, Mr. Chair. So Senate Bill 637, we actually came to peace in the valley between the Commonwealth attorneys and the clerks of court in regards to concurrence on deciding a collector of choice in regards to fines and fees. And so what the amendment does is makes that relationship permissive and allows 30 days notification in between of letting the Commonwealth attorney know, informing the clerk of court of said collector.
Yes, so Senator, I heard the parties went to marriage counseling and
they did.
Came back with a property settlement agreement.
They haven't decided who's taking the china yet.
Okay, so you have a written amendment somewhere? Yeah. Taylor, do you have something you're holding, or is that the amendment?
I do have this, Mr. Chair. I can try to orally report it if everyone wants to follow along.
Go ahead.
All right. This would be, so on line 45, you would strike after board, where the new language starts, strike prior to contracting with private attorneys or private collection agencies, and instead we'd be inserting at least 30 days prior to the execution of a contract, and then I think it would pick back up pursuant to clause 1. And then on line 46, we would strike notify and obtain the concurrence of, and instead insert consult with. So it would pick up consult with the clerk of the circuit court. And then on line 47, you would strike notice and concurrence.
Okay.
And insert consultation.
Okay, Senator Deeds moves, Senator Carroll Foy seconds. The line amendments, all those in favor say aye. Aye. Anybody opposed? No. Okay. Sounds like, does anybody oppose the bill at this point? And this does not have to go to finance, right? Okay. Clerk, open the roll.
Have we adopted the?
Yeah, we adopt the amendments, yeah.
Ayes 14, no zero.
All right, Jordan, is your next one short? You want to put?
It's short.
You want to put senior citizens on the jury now?
Yes, sir.
Okay, so we're on a 638.
My mom just turned 73. She'd be offended. Senate Bill 638 is a change in the age for jurors in the Commonwealth. Currently, they age out at the age of 70, while we have our judges that sit until the age of 73, and being able to have that, I think, matches only goes to expanding the juror pool very specifically. As we know that we have an elderly population that's aging in the Commonwealth, this provides a much larger pool for those to be able to select for a jury. With the bill that passed a couple years ago out of the House and Senate was signed into law, we know that we have an increasing number of jury trials now, and so this will go a long way to making sure that our clerks and those around them can fulfill their requirements.
Okay. Wait a minute. Is there any opposition to the bill?
I'd like to reduce the judge's retirement age to 70.
Mr. Chair, Senator Robin.
Senator Jordan, you sure you want to say something? You might.
No, sir.
Okay. All right. I think Senator Carol Foy moves and Salim seconds that we report the bill. All those in favor, vote yes.
Thank you, Mr. Chair.
Stanley.
Okay.
Ayes 15, no zero.
Open chain, you've got two, and I know VASAP is here for one of them. They've been quietly waiting to do your VASAP bill, which they don't like. You want to do that one first?
Sure, and if I can do it from here.
Yeah, so Senate Bill 690 is before us.
Yeah, I'm going to make a motion on 690, but before I do, I want to say a couple of things. Our ASAPs around the state are under enormous fiscal pressure. I can tell you from the perspective of the ASAPs in our area, they operate on a shoestring budget. A couple of years ago, we adopted legislation that took all of the interlock money that was going to our local ASAPs and sent it to Richmond, to the ASAP board in Richmond. For a year after that, they were distributing it out around the state. But after that, last year, they distributed $0 around the state. Something has to happen. This is simply a bill to try and extend a little bit of a lifeline to some of these ASAPs. In my area, the judges love the ASAP. It is absolutely wonderful, wonderfully run. The Commonwealth's attorneys like it. The defense lawyers value it. It is a strong program. This was to increase the maximum amount of the fee that the judge could assess. I'm going to move to strike this bill, but I want you to know that I'm going to be back next year unless there is something that is done to help relieve some of the pressure on some of these local ASAPs. You just can't grab the money and not distribute it back to these operations and expect them to continue to survive. So with that, I move to strike the bill.
Thank you, Senator. It's been moved and seconded we strike the bill. Speaking to the motion really quick, I'll just say that Senator Stewart and I both serve on the VASAP Commission board, and there's no question that a lot of these localities are operating on tight budgets. A lot of localities end up having to supplement the budgets because they don't have sufficient funds to cover their expenses, and it's just been clear to me serving on there with the the budgets are tight. So
Mr.
appreciate your concern. Senator Stewart?
And actually, I met with Senator Obenshain and some other folks, and they highlighted some things to me that I was unaware of. And so I think this is probably worthy of us taking this up before the commission and taking a look at it, because, I don't know, they're taking in a lot of money, but a lot of it's not going back to the commissions apparently. And so I think we need to chat about it and just see where it's going.
Senator, you want a letter?
think.
You want me to write a letter to Senator Stewart?
Sure.
I'm hoping to nominate you for chairman for the next meeting. So you want to write it to yourself?
All right, his motion to strike. Clerk will open the roll.
Ayes 15, no zero.
Okay, now Senator Obenshain wants to take us back to law school. Senate Bill 470.
Rule against perpetuities.
I would move to carry that over to 2028.
No.
9 years.
All right.
I have a couple of lifelines out here, but Virginia stands alone as a state that has essentially allowed parties to opt out of the rule against perpetuities with respect to trusts. It has created a tax issue having no termination date. This is a tax issue that is unique to Virginia because these trusts can exist in perpetuity. What this does is it seeks to avoid that tax trap and establish a 1,000-year maximum duration for these trusts so as to preserve the ability to have a very, very long duration, but to avoid the federal tax trap into which we found ourselves as a consequence of our unique position as a state that has decided to allow parties to opt out. So with that, I would, and this is an initiative of the Wills, Trusts, and Estates section of the Virginia Bar Association, a group with which I have had a complicated relationship over the past 5 years, and I am delighted to be able to work arm in arm with them on this piece of legislation.
Those guys know how to party.
Yeah. And Senator, does this apply per stirpes per capita, and does the res ipsa loquitur apply?
Indeed.
All right.
You're confusing trust and torts.
I'm confusing lots of things. Is there anybody opposed to the bill? A bunch of unhappy heirs? No? Okay. All right. It's been moved and seconded that we report the bill. Clerk will open the roll.
It'll be right.
Senator Deeds. Ayes 15, no zero.
Okay, so we've got a few left in the docket. The committee members here. Who has the easy one? 138? Carol Foy? Okay, Carol Foy, let's do 138. Permissible venue, wrongful death actions.
Oh,
Boyd
yes.
Graves bill.
Move to report.
We have to take some testimony here. Carol Foy, go for it.
Okay, thank you, Mr. Chairman. This bill, Senate Bill 138, Wrongful Death Administrator Appointment Bill, was a bill that was vetted by the Boyd Graves Conference, encompassing Virginia State Bar members, and is supported by the Virginia Trial Lawyers Association. This is a cleanup, very technical cleanup bill. The code provides a mechanism by which an administrator can be appointed for litigation purposes only to represent the estate of a decedent anticipated to be named as a plaintiff or a defendant in a personal injury or wrongful death action. For purposes of protecting deceased defendants from being sued in an improper venue, the General Assembly added a caveat that such administrators be appointed under certain jurisdictions where venue would have been proper if the decedent was still alive. Unfortunately, some courts have been appointed administrators in jurisdictions wherein venue would have been improper had the decedent lived. Compounding the problem, some courts have found after the filing of an anticipated personal injury or wrongful death action that the appointment was therefore invalid when made because it had occurred in a jurisdiction where venue would not have been proper if the decedent was still alive.
Okay, Senator, I think it just gives us more flexibility on where the venue lies for a wrongful death case, pretty much. And does anybody oppose the bill?
Move your report.
Doesn't look like it. Okay, it's been moved and seconded. The bill be reported. Clerk will open the roll. Okay, now Senator Rome. Okay, sorry, Stewart.
Ayes 15, no zero.
Great. Senator Rome has been in and out and waiting dutifully and came back from local government to do 290 to us, which this is going to be quick, right?
Yes, Mr. Chair. Mr. Chair, members of the committee, SB 290 is an agency bill from the Office of the Executive Secretary of the Supreme Court and its recommendation to the Judicial Council of Virginia regarding guardianship reform. First, clarifies that the circuit court clerk must send a copy of the certificate of qualification to the local Department of Social Services. Second, the bill also specifies a time frame for guardians to file an annual report with the local Department of Social Services. Third, the bill provides for a cover sheet for guardianship and conservatorship petitions for the collection of information about individuals subject to guardianship. And with that, I think we've got someone from OES who could speak on the bill.
I don't think that's probably going to be necessary. Anybody opposed? Is that a judicial council? It's been heavily vetted.
Move your report.
It's been moved and seconded. The bill be reported. Clerk will open the roll.
Hold on.
Ayes 15, no zero.
All right. Bill
Perfect.
reports. Thank you, Senator Rome. Thanks for your patience for 30-second speech for all that wait. Okay, we got be out of here in 1 minute. Anybody else got anything simple? Perry. Perry's got which one? 350? You think that's simple? All right, we'll see. 350. You got one too?
I've got something from the Judicial Council.
Oh, the quarters for magistrates.
Mr. Chairman, members of the committee, this is Senate Bill 350, the Virginia Human Rights Act. It does two things. Currently, I don't do a lot of these cases, but I had a number of some employment lawyers contact me and say that what was happening is they were going through the process that's provided in the bill, and they were failing to get, for those of you who don't know, you have to get a right to sue letter to be able to go into courts to file your potential discrimination lawsuit. What was happening is that these letters were not always forthcoming, even though the statutory period had lapsed. Despite repeated requests, still no letters coming, and therefore these people were essentially barred, not essentially, they were absolutely barred from going into the courts and trying to seek any kind of remedy, have a court hear whether or not they had a lawsuit or not. But even to have it addressed on its merits.
And Senator, under federal law, when you do these right to sue letters to the feds, the letters come back pretty quickly, or there might be a time period under federal law, I think, right?
I think that's right. And this bill seeks to address not only the Office of EEOC and the state level board, because sometimes the state level group sends them out to EEOC and has them handle it. This just makes sure that whichever place is handling it, that they can get a right to sue letter. If the right to sue letter does not materialize.
Okay. Senator, people want to know if there's any opposition to the bill.
Not to my knowledge.
Second.
Okay, it's been moved and seconded. The bill be reported. Clerk will open the roll. Good work, Senator
Ayes 15, no zero.
Okay, next, Senator Deeds has a quick one, I think. 386 is also Judicial Council recommendation.
I hope it's quick. This is for Judicial Council recommendation. It adds language that defines the minimum requirements for suitable magistrate facilities. Right now, the law says that you've got to provide suitable quarters for courthouse facilities that are not secure, out of repair, or dangerous. The code sets out a process by which the circuit court can order such issues to be addressed. There is no similar provision in the code regarding magistrate facilities. While some localities have been willing to address security concerns with magistrate facilities when they arise, others have not. This bill requires that sufficient space be provided for equipment used by the magistrate's office, and that the office be located in a facility that's open to the public. It goes on to provide.
Well, it doesn't cost anything. It's not going to finance. Okay.
It could be, could cost localities something. Yeah, no question about that.
Okay, so hold on. So Senator
Quick
Peake, go ahead.
Mr. Chair, do we, Senator Deeds, any idea approximately how many localities have a problem with this?
It came from the Judicial Council. I don't know, but I think there's somebody here to testify, or there was. No. There were.
Somebody here from OES to offer some clarity. Oh, here they come.
Did you get that? Is it in there that you got to give me?
Okay, hold on, guys. Hold on, be quiet.
Mr. Chairman, members of the committee,
Yeah.
Alyssa Padden with the Office of the Executive Secretary. I believe the question was how many localities have issues. I would say it varies. In some cases, it's a very small issue. Perhaps the magistrate is in rented office space and there's no call button for security. It may be something that can be addressed relatively easily, but others have more complicated situations.
Mr. Chairman.
Senator Obenchain.
I mean, isn't it true that the biggest problems are going to be in rural and poor localities?
I do think that's true. However, I would say that the way the bill is worded, most of the requirements follow the phrase "where practicable." So, where practicable, such quarters shall have X, Y, and Z. The mandatory provisions of the bill are in the beginning section beginning on line 15, which basically just says that the localities have to provide enough space for the magistrate to be able to conduct their business and transmit paperwork.
So, Mr. Chairman.
Senator Obenchain.
So does lack of financial resources make it not practicable, or?
I believe so. Essentially, the idea is just to give staff in our office another tool when trying to work with localities to have security issues addressed. As I think Senator Deeds presented, most localities have been willing to work with us. There are a few where we're hoping to have another tool in the toolbox to when we work with them and approach them to try to address concerns. But we're certainly aware of what the practicalities are with regard to funding and are happy to just have a conversation with localities about that and try to make some progress.
Okay.
Mr. Chairman.
I thought this was going to be quick.
It's going to be quick.
Okay, Senator Stewart.
Mr. Chairman, this is a function of necessity. The magistrates are supposed to be there to serve the public, and they're actually supposed to be a line of defense for the public if they're doing their job, and they've got to have office space to do it in. So I think we need to support this bill and move it on. I'd move that the bill be reported.
Okay, any further discussion? Okay, it's been moved and seconded. The bill be reported. Clerk will open the roll. We got one more after this.
Ayes 15, no zero.
Thank you. Okay, we have one more I want to do, which is Senator Stanley has Senate Bill 95, which I believe reported out. It's identical to the bill we reported out here unanimously last year. Senator Stanley, is there any? This has to do with preliminary advising people of their rights on a PBT and the consequences of that. Is this bill identical to the one reported out last year?
Mr. Chairman, members of the committee, is identical to the one, and what we're trying to do is to provide an exclusionary rule. If they haven't, the only amendment I would do is to strike the word adequately.
Strike a what?
The word adequately, which is on line 38.
And Mr. Chair, I think the amendments have been distributed
it's already on there?
to the members. It would strike adequately in both places and then also add at trial after cause on line 39, right. But they should be in your packets.
No, wait. Amend it first.
At trial? Where, Mr. Chairman?
Senator Stanley, Mr. Benjamin has a question for you.
Me?
So we're adding, Mr. Chairman, a determination of probable cause at trial. Trials don't involve probable cause. If, Mr. Chairman, the patron seeks an exclusionary remedy for trial purposes, then the exclusion should be, nor shall any analysis of blood or breath sample obtained pursuant to 268.2 be admissible at trial. The probable cause language only deals with probable cause for an arrest.
Hold on, Benjamin. I didn't put it in there, okay, buddy? I'm not wedded to it, all right? I mean, dang, I'd rather talk about the rules against perpetuity at this point.
Senator, I think Mr. Benjamin's point is that if you do it the way you wanted, you might create civil liability, whereas if you put it here, it just where he's suggesting it creates an evidentiary rule.
Let's take out at trial then.
Mr. Chairman, we can write the bill however the patron wishes, but probable cause is not an issue at trial.
Okay. So,
Well,
Senator
in a
Stanley.
suppression hearing it is. but-
Senator Stanley, I think the suggested friendly amendment is on line
Amend the
39.
amendment.
After shall not be admissible, add at trial. I think it's the suggested friendly amendment. Is that good?
Yes, that's fine.
Okay, Senator Stanley.
Wasn't
moved.
mine.
What?
Mr. Chairman, PBT results are not admissible at trial.
There are
It's-
sometimes.
Well, what's admissible at trial, first you're stopped, Mr. Chairman, and then you do or don't take the preliminary breath test, but once you're arrested, then you have to take the real breath test down at the station.
Right, but
That's what's admissible
Right, but
at
Mr.
trial.
Benjamin, the current law says that if you challenge probable cause, PBT evidence can be used. And I agree, I rarely see it come in because I make lots of other objections that keep it out, but it is admissible for probable cause under the statute right now.
Probable cause for arrest.
For arrest, Mr. Chairman.
Right, that's right. For
'Cause
arrest
you-
only.
Exactly.
Hold on, guys, we got to go through the chair here. We're going to get out of control here soon. We're getting all punchy after being here for 5 hours.
Hey, look, Mr. Chairman, there was a time there I went to a tattoo parlor and I told the guy, do
Senator
what you
Stanley.
want, and that was a wrong thing to do. So, but I'm willing to give it a second shot here.
Second chance?
So, hold on, guys, wait a minute. Where are we on the amendment? Senator Stanley, do you want to make that amendment?
Which, mine?
Mr. Benjamin's
Yes.
amendment, shall not be admissible, insert at trial. Or at what,
The
at a
amendment-
probable cause hearing?
The amendment would be, in addition, you would say, nor shall any analysis of blood or breath sample obtained pursuant to 18.2-268.2 be admissible at trial.
I think his amendment makes better sense.
And he's a great tattoo artist, too. Let's go.
Hold on, wait a minute. The chairman questions whether or not it ought to say at any motion to suppress, because it's not admissible at trial ever, right? So it should say motion to suppress.
Mr. Chairman, what my suggestion would do is this. If there is a motion to suppress, then the preliminary breath test would not be admissible at that motion to determine whether or not the arrest was based on probable cause. In addition,
Mr. Chairman, if you contest probable cause for the arrest, it can come in.
Yes.
It says
And
that
so I
right
think
now.
what
It
he's
says that.
trying to do is not allow it to come in for any circumstances for purposes of probable cause for arrest. So do you still like your amendment?
well, it depends on, I'm just trying to write an amendment to suit the patron because I understood that if the warning is not given for the preliminary breath test, then whether the ultimate breath test at the station would be admissible at trial. Does the patron wish to exclude that?
Mr. Benjamin, this is getting more complicated than I anticipated to be, so why don't we take this by to the next meeting so we can clean up the language. Senator Sturman has shown up after waiting around for 4 hours. Is yours quick? I don't know. Yours is, you want to make it hard for big private equity companies to buy rental real estate, right?
If you want to continue it to Wednesday, I'm totally fine with that.
I mean, given the late hour, that's probably good. Yours isn't simple, but it's well intentioned. I just don't think it's simple. So okay, so everything will be moved to Wednesday.
Thank you.
And pending. By the way, colleagues, pending an agreement from the minority leader about waiving reads on Monday, Tuesday, we might have to take up our remaining like 50 bills Wednesday. But if we get to have if we waive reads Monday, Tuesday, then we can have another meeting on Monday. Take up the remaining bills Monday. So anyway, that's where we stand right now. The committee will rise.
The Senate of Virginia, Richmond, Virginia.